Honourable members, at the commencement of public business, item listed for presentation of papers. Honourable Minister for Finance.
Mr. Speaker, I may want to present the papers on behalf of the Minister of Finance. That is for a Roman number 1 to Roman number 4 on behalf of the Minister for Finance.
Very well. Honourable.
Suppliers credit agreement between the government of the Republic of Ghana, represented by the Ministry of Finance, and Measures Dongfang Electric International Corporation for an amount of $243,600,000 United States dollars for the procurement of standard gauge rolling stock.
Paper is duly presented and is referred to the Finance Committee for consideration and report. Aye.
EKL Facility Agreement between the Government of the Republic of Ghana, represented by the Ministry of Finance and Dutch Bank AG, as arranger, structuring bank, and facility agent, for an amount of €523 million to finance the construction and sections of the Western Railway line on standard gauge for Tade, Port, and Huni Valley.
The report is duly presented and is referred to the Finance Committee for consideration and report. Aye.
Commercial loan agreement between the Government of the Republic of Ghana, represented by the Ministry of Finance, and Dutch Bank AG as arranger and facility agent, for an amount of €75,657,500 to finance the construction of the Western Railway line and standard gauge for Takoradi, Port, and Huni Valley.
The request is duly presented and is referred to the Finance Committee for consideration and report. Ivy.
Request for the waiver of import duties, import VAT, NHIL, Get Fund levy, Exim levy, special imports levy, and domestic VAT, amounting to the Ghana cedi equivalent of €72,287,717.64 on project materials and equipment to be imported for the execution of the construction of sections of the Western Railway line on standard gauge for Takoradi Port and Huni Valley.
The request is duly presented and is referred to the Finance Committee for consideration and report. B. I. Minister for Railway Development.
Mr. Speaker, for 4B, the Minister for Defense will do the presentation on behalf of the Minister responsible for Railway Development.
Thank you very much. You may proceed.
Addendum number 1 to the contract agreement between the Government of the Republic of Ghana, represented by the Ministry of Railways Development, Ghana Railway Development Authority, and the Measures Afcons Infrastructure Limited of India, for an amount of $48,843,490 United States dollars and 54 cents for the variation in respect of the ongoing railway construction works between the ports of Tema and Impadan.
The agreement is duly presented and is referred to the Committee on Road and Transport for consideration and report. Aye, please. Honourable Minister.
Supply contract agreement between the government of the Republic of Ghana, represented by the Ministry of Railways Development, and Messrs. Dongfang Electric International Corporation for an amount of $243,600,000 United States dollars for the procurement of the standard gauge rolling stock.
The agreement is duly presented and is referred to the Committee on Road and Transport for consideration and report. Aye.
Commercial contract agreement between the government of the Republic of Ghana, represented by the Ministry of Railways Development, Ghana Railway Authority, and Amandi Investments Limited for an amount of €500 million for the construction and sections of the Western Railway line on the standard gauge for Takoradi Port and Huni Valley.
The agreement is duly presented and is referred to the Committee on Roads and Transport for consideration and report. C. Chairman of the Committee, Finance. Aye.
Report of the Finance Committee on the sum of $11,896,477,566 Ghana cedis as supplementary estimates for the 2020 financial year.
The report is duly presented as for distribution. Aye.
The Speaker, to all through to Romans 6, the reports are not ready. We are yet to meet on these. From Romans 2 all the way through to Romans 6, the reports are not ready.
So by that you are finished?
Yes.
Thank you very much. D. Chairman of the Committee on Local Government. Chairman, Committee on Local Government.
Yes. Speaker,
Honorable Leader.
we stamped that one down, and we call it so for E. With D and E, we stand them down, and we can now deal with item number. The Speaker, we can begin with the Minerals Income Investment Fund here.
With the
Minerals Income Investment here,
consideration stage,
which is item number 7.
item 6.
7.
Item 7.
Yes. On page 19.
Item 7 on page 19.
Yes.
Thank you. Consideration stage. Honorable members, item listed 7, Minerals Income Investment Fund, Amendment Bill 2020, at the consideration stage. Chairman.
Mr. Speaker, on page 19 of the order paper, clause 1, amendment proposed. Paragraph A,
Section Act 978 amended.
Please.
Mr. Speaker, clause 1. Amendment proposed, paragraph A, line 3. Delete be free to, so that paragraph A reads hold direct or indirect equity interest in a special purpose vehicle in any jurisdiction in furtherance of the objects of the fund, and each special purpose vehicle shall operate as a regular commercial company. Mr. Speaker, the words be free to add little value to it. They are already empowered to operate as a commercial company, and so we want the be free to delete it.
Thank you. I'm next for your consideration. And I put a question. All those in favor of the amendment say aye. Those against say no. The ayes have it. Yes, Honorable.
Mr. Speaker, I see the wisdom in the present provision, the import of the provision, but I believe that we have a drafting style in capturing this essence. We don't list the laws like this. What we say is that, notwithstanding the provisions in other enactments, A, B, C, D, or despite the provisions in other enactments.
Can we ask the draft person to consider the formulation?
Mr. Speaker,
Shall we ask the draft person? Oh, please. You cannot speak on your chair. Honorable, please. Shall we decide on it and then ask the draft person? I'll put a question and ask the draft person to look at this. All those in favor say aye. Those against say no. The ayes have it. With the rider that the draft person should appropriateness of the formulation. And the question is that clause 1 as amended should stand part of the bill. And all those in favor say aye. Those against say no. The ayes have it. Aye.
Section 4 of Act 978 amended.
Chairman of the committee. Chairman of the committee.
Yes, Mr. Speaker. Roman 2, clause 2. Amendment proposed. Paragraph C. Paragraph C. Delete and insert the following. The substitution for section 3 of a new 3, the fund shall not provide credit to government, a public enterprise, a private sector entity, or any other person or entity. Mr. Speaker, in the bill, section 2, C, it's been deleted and a new one inserted. what we have says that the fund or special purpose vehicle shall not provide credit to government or public enterprise. We want to restrict that to the fund, because the special purpose vehicle, as already stated, is a commercial entity, and if it so decides to advance credit to any public enterprise for that purpose, we don't want restrictions on the SP, but the fund, no.
Yes. Honorable Dekru.
Right, Honourable Speaker, thank you for the opportunity. Can the Speaker, this fund, mineral royalties are big issues in this country in terms of revenue to the state. Now, the Chairman's amendment is seeking to say that the fund that we are setting up cannot borrow or cannot provide credit to government, public enterprises, and other things. Can they be helpful enough to just explain to us the rationale behind this new provision?
Honorable Chairman.
Someone said he didn't get it. We just trying to find out from the chairman if he can help us understand the rationale behind why the new making cannot provide credit to government, any public enterprise, and other things. Because in any case, it is our mineral royalties that will form the basis of this fund, irrespective of which other funds may come from elsewhere in the future. So why are we saying that this fund cannot provide credit to government or any state enterprise or individuals?
Honorable Chairman.
The Speaker, the current Act, the Act 978, in Section 4.3, that in the performance of its functions, the fund or special purpose vehicle shall not provide credit to the government, public enterprise, private sector. That's what pertains in the Act. Now we are saying that the special purpose vehicle is going to operate as a commercial entity on its own, not under governmental control. So what we are doing here in the new amendment is to say that as for the special purpose vehicle, we don't want to put restrictions on it, but the fund, which is subject to the PFM, the SIGA Act, and all other provisions, cannot and shall not provide credit to the government as pertains in the Act. So that is the new amendment we are proposing, that for the special purpose vehicle, they can advance credit, but not the fund.
We're only deleting special purpose vehicles.
Honorable Dekru.
Thank you for the Mr. Speaker. I believe that events helps us so that when we are enacting new laws, we can be guided. Mr. Speaker, this year the health crisis that afflicted us was unanticipated. We never anticipated it. And by so, to the extent that every government had to borrow from the central bank. So if we say shall not, I believe if tomorrow we run into emergencies and we have funds sitting there, we should be able to fall on it. So I suggest that instead of shall not, we could say may not. May not, so that there's my humble position in the matter.
The honorable member's point is, shall is mandatorily prohibitive. May gives room for discretion, so that where necessary, that may be applied. Yes, honorable members. Yes, honorable majority leader.
Mr. Speaker, the fund, the accruals to the funds in Section 31 of the bill of the Act, there is a disbursement formula for the fund. So the fund has a prescribed disbursement formula in Section 31 already. So what is being provided is that You cannot go outside the prescribed formula to take the money, regardless of the exigencies, and maybe give it to government as a credit when you have not, like get funds. There is a prescribed formula. Can government take the fund as credit to itself? It cannot be done. The same thing applies here in Section 31 of the Act, that when the disbursement has not been made, you cannot just go and get money that I have a problem. So I want to give credit to government from this fund. That is what is being stipulated here. Already we had in that provision, which is what the chairman read, that in the performance of its functions, in 4.3, in the performance of its function, the fund or a special purpose vehicle shall not provide credit to government, public enterprises, private sector entities, or any other person or entity. That is what is in the original act. What is being taken out is the special purpose vehicle. So the fund now cannot provide credit to government or public, any public enterprise or private sector entities, because already the amount in the fund is meant for a purpose specified to one. So before the distribution, then government comes in to say that I have a problem, give it to me as a credit, and then it's advanced to government as a credit. That is what is being avoided. It's just for the avoidance of doubt.
Honorable Rafemiko. Yes, Honorable.
Mr. Speaker, I think the leader has provided further explanation. That he used an example of the debt fund. My colleague just gave an example. Indeed, COVID has made this world a different world than it used to be. I'm sure if debt fund had $1 billion sitting in it, Mr. Speaker, I have no doubt we would have fallen on that fund today because of the situation in which we are. But to make a law and say, under no circumstances shall we attempt to use that fund as a state and even pay back. We are not even saying take the money and get away without bringing it back. Mr. Speaker, with COVID in mind, I feel I'm not a lawyer, but there should be another way of crafting this, or there should be another clause, a clause which will say that, however, in other circumstances which necessary, we should be able to do that, but it shouldn't become the norm. But out of the ordinary, there should be a way out. Well, I can see leader disagreeing, maybe.
Honorable Yeri Chile.
Mr. Speaker, thank you very much. This amendment, if you don't have the three documents we are looking at, it will be difficult to understand. We have the Act itself, which is Act 978. Then we have the bill making the proposal to change in sub-clause 3. And the bill seeks to expand the sub-clause 3. And in the process, they did not carry the correct position. That's why the committee is making the amendment. Now, for it to reflect what when you combine the two documents, that is the bill and the act, this is what should be the amendment proposed. And in the act itself, it was also forbidden to use it. It is not that it is now going to do it. It was already forbidden in the act to do so. So this one is further elaborating on the provision in subsection 3 of the act. So I think that the amendment is proper in that case.
Chairman, will you affirm that then we put
Yes, Mr. Speaker, if you can put the question on the course.
The true intention is that this will be mandatory and admit of no exceptions.
Speaker, The exception here it's why we are taking out the special purpose vehicle.
Very
And it is to affirm the independence of the special purpose vehicle. So government can borrow from the special purpose vehicle, but not the fund.
All those in favor of the amendment say aye. Those against say no. The ayes have it. The amendment is carried. Any further amendments? Chairman.
There's no further amendment in clause 2, but
The question therefore is that further amendment to clause 2?
Yes, Mr.
Please
Speaker,
go.
I want to propose a further amendment to clause 2. Mr. Speaker, I'm proposing that we delete entity so that the rendition will be the fund shall not provide credit to government, a public enterprise, a private sector entity, or any other person. Mr. Speaker, if you said any other person, the interpretation of person includes entity, so there is no need bringing all entity. That's why I'm proposing the deletion of all entity.
After government, there's no need for entity.
Mr. Speaker, you delete all entity at the end of the provision so that it will end at any other person. Mr. Speaker, the reason for the deletion of all entity at the last end of the sentence is that any other person, a person by our interpretation act, includes a body corporate or other entities. So once you are saying any other entity, any other person will include entity. So there is no need saying any other person or, because entity is embedded in any other person.
So every entity is necessarily a persona,
Yes.
a way of person.
Yes, Mr. Speaker, if you say a person, it may be a natural person or a juristic person.
No, but what about an individual? Is it an entity? Is an individual an entity?
Mr. Speaker, Mr. Speaker, there is a public sector entity, and the closing words are any other person. And because you are saying any other person,
Don't we often say in the law, any other person, body, or authority, just for the sake of clarity? Honorable leadership.
I think that the issue he's raising, if we want some of the laws we have passed specify entity, and they use it as entity, then we have persons, as we all understand in the Interpretation Act, which can include a corporate body. Therefore, even if we leave it here, it doesn't have any harm in it. But it depends on whether we have used the entity in the Act itself, the Act we amended. If we have done so, there is nothing wrong keeping the entity. But if we haven't, and it is just any other person, then his argument will be sound. Thank you very much, Mr. Speaker.
So you don't support the amendment? Chairman, you don't support the amendment? Honorable, you want to drop the amendment? You are being requested to do so.
Mr. Speaker, the House can take a decision on it.
All those,
so
in,
that
favor,
subsequently,
all those in favor of the proposed amendment say he wants a division on the proposed amendment. All those. Yes or no?
Thank you, Mr. Speaker. Mr. Speaker, this is the Interpretation Act of 2009, and my colleague made reference to the definition of a person. There's no such definition of a person in the Interpretations Act. So I want him to correct. This is the Interpretation Act.
And what does it say?
It doesn't define a person.
Then it doesn't help us.
You don't have yours, I'm telling you. There is no definition of a person as alleged by Honorable Ahiafu.
Which means there's a vacuum there. Yes, Honorable Majority Leader. Honorable, that one is not.
I want to draw his attention to the fact that a person has been defined in the Interpretation Act. Therefore, there is no need defining a person in this law again. And the definition of a person in the Interpretation Act includes an entity. If it is in the Interpretation Act, I'm talking about Interpretation Act, not the Interpretation Section.
Honorable, do you have anything to read? Honorable Majority Leader.
Mr. Speaker, in the Act, the original Act, the formulation is this. In the performance of its functions, the fund or a special purpose vehicle shall not provide credit to the government, public enterprises, private sector entities, or any other person or entity. Now, the amendment is just to delete or special purpose vehicle. That is the import of the amendment. Our colleague is proposing that we don't need or entity at the end. The Speaker, that makes some sense, except that in the normal usage of our words, sometimes in these contexts, we are using ministries, departments, and agencies. Where would you situate such a cluster? Maybe they will come under entity. But the Speaker, as far as I'm concerned, it does no harm if we even repeat what is there. It does no harm. So I would suggest that we leave it and allow it to go.
Honorable, we will either abandon it or we'll put a question. If you want to insist, let's put a question.
Mr. Speaker, thank you. Mr. Speaker, I recall that just last week, we fell into a similar problem. And that was, how do we classify, for instance, organs of government? So we were not able to classify them into the same category as, for instance, departments of state and state institutions. So we could borrow that physiology that we employed just last week in this house to be able to cater for this.
So that in formulation you will say?
So that in the formulation we will say that the fund shall not provide credit to government, a public enterprise, a private sector entity, or any other person or organs of state. We employed a similar provision, just we can have recourse to that, just to tidy it up, for the sake of internal consistency in drafting of the House.
Chairman, Honorable Yudechire, are you in support?
I said that if in the act we are dealing with, we have used the word entity, then we need to continue it with the use. Because it doesn't, and fortunately, the majority leader has pointed out that it is in the act itself, the section, the subsection that we are amending. And therefore, that's why I'm saying that once we have in the original act, there will be no point trying to now say we should delete it. That's what I explained.
Honorable Minority Leader.
Speaker, I've been trying to persuade the Honorable Bernard to abandon the amendment, having heard from the majority leader that in the original act, the same entity is used. He should not insist on its deletion. I thank you.
Thank you. I'll put a question.
Mr. Speaker, I will not insist. I will not insist, and I will drop the amendment.
Withdraw the amendment. Amendment withdrawn. Chairman, any other issue?
No other issue, Mr. Speaker.
Then the question is that clause 2 as amended stand part of the bill. And all those in favor say aye. Those against say no. The ayes have it. Clause 3.
Section 25 of Act 978 amended.
Chairman, any amendment?
There's no advertised amendment.
The question, therefore, is that clause 3 should stand part of the bill, and all those in favor say aye. Those against say no. The ayes have it. Clause 4.
Section 31 of Act 978 amended.
Chairman,
Mr. Speaker, again, no amendment here.
the question is that 4 stands part of the bill. All those in favor say aye. Those against say no. The ayes have it. Clause 5.
Section 32 of Act 978 amended.
Chairman,
Mr. Speaker, Roman 3, clause 5. Amendment paragraph B, section 3, line 3, delete accounts and insert accounts with the S.
thank you very much. Any proposed amendments for your consideration, honorable members? I put a question. All those in favor of the proposed amendment say aye. Those against say no. The ayes have it. And the question is that clause 5 as amended stand part of the bill. All those in favor say aye. Those against say no. The ayes have it. Clause 6.
Section 33 of Act 978 amended.
Honorable Chairman, there's no listed amendment.
No.
Very well. The question is that clause 6 stand part of the bill. And all those in favor say aye. Those against say no. The ayes have it. IV, clause 7.
Section 35 of Act 978 amended.
Chairman,
Speaker, Roman 4. What we have is an amendment in the opening phrase, which is essentially not part of the bill proper. So the amendment proposed that in the opening phrase, we delete amendment and insert enactment. That the principal enactment is amended by the substitution for section 35, but it is just in the opening phrase and not the bill itself.
very well. Honorable members, for your consideration. Honorable Minority Leader, any?
Mr. Speaker, mine is just the rendition in 7.2. Maybe even as we accept it, you may have to direct the draft person to look at it. It reads, further to an allocation agreement. Is it allocation we want to use or a stability agreement? Then entered into in accordance with section 41. The arrangement there, when you say section 41 of which act, then it continues. Parliament may, in accordance with Article 174 of the Constitution and in accordance with the Income Tax Act. Mr. Speaker, when Parliament is exercising its power under Article 174, we will only be guided by the Act. So I don't even think that we should be referring to the Income Tax Act. If Parliament wants to grant an exemption, the power is vested in Parliament under Article 174. Therefore, you don't need to say in accordance with Income Tax 2015. No, we have the power. It is our mandate. If we want to grant it, whether income tax, excise, VAT, it is within our power. So that's my reasoning. Thank you. I know you said I'll come to you.
Honorable Irechi.
Thank you, Mr. Speaker. Mr. Speaker,
The Income Tax Act is also an act exercised or enacted relying on the powers of Parliament. So if there's a need to do anything under that, in that respect, the act is to guide Parliament in doing that act. If we need to amend that, we will then have the power to amend it. But until that is amended, that should be the guiding law which should, under which Parliament would act. So, yes, we have the power in accordance with Article 174, but we have enacted a procedure for doing that, and that is what comes under Act 896. And therefore, it is not out of place to refer to the Act. And thank you, Mr. Speaker.
Honorable Irichiri.
Mr. Speaker, the bill is saying in subsection 2, subclause 2, that further to an allocation agreement entered into in accordance with section 41, Parliament may, in accordance with Article 174 of the Constitution, and in accordance with the Income Tax 2015 Act 896, grant additional tax exemptions to special purpose vehicles. Now, if you look at the Act, Section 41 of the Act we are at, and unless you, as the leader is saying, if we say of Act 978, which is the Act we are amending, that's where Section 41 is referred to. In it, the provision is saying in subclause 3 that an allocation agreement is subject to ratification by Parliament. So this is why, after you mentioned allocation agreement, you first questioned the issue of allocation agreement and wanted to say that's different, but the allocation agreement is in the Act. And that one in the original Act is subject to ratification by Parliament. And that is what is being repeated. So if there is the problem will be that we should specify which Act 978. But it is the Act that we are amending. So normally you may not mention it. But if you need to add it. If you add it, it is so. Now, I think that if you also look at the Constitution, I'm saying that I don't know whether it's 175, Article 175, or rather 174.
It's 174.
So if it is 174, then it is perfect in terms of
174.
Thank you very much. Honorable Majority Leader.
Mr. Speaker, I believe that what is being done is appropriate. First of all, as the honorable member for One West has indicated, the reference is to section 41 of the original Act, and section 41 is the allocation agreement. And the allocation agreement, the minority leader wanted to know what it is for. And therefore, in the original 41, and indeed, it's also in the interpretations column, where an allocation agreement means an agreement between the fund and a special purpose vehicle or other entity, which by which the fund assigns all or a portion of the minerals income by way of investment to the special purpose vehicle or other entity. And then B follows. So the allocation agreement is vividly explained. The Speaker, and the other one is Article 174 of the Constitution. And 174 of the Constitution applies because really it relates to a grant of a tax exemption. That is in 1743, Article 1743. And further to that, this House has passed Act 896, that is the Income Tax Act 2015. So we have also to relate to that, so people have a better understanding of what is intended to be done. Mr. Speaker, I believe we are right in what we are doing.
Chairman.
Mr. Speaker, I think the
But we can
On that, I'll put a question then, as further amended. All those in favor of the amendment say aye. Those against say no. The ayes have it. Any further amendment on clause 7? The question is that clause 7 as amended stand part of the bill. All those in favor say aye. Those against say no. The ayes have it. Clause 8.
Section 40 of Act 978 amended.
There's no this amendment. Chairman, any
There's no
question therefore is that clause 8 stands part of the bill. All those in favor say aye. Those against say no. The ayes have it. Clause 9. Chairman.
Section 41 of Act 978 amended.
Anything? The question therefore is that clause 9 stands part of the bill. All those in favor say aye. Those against say no. The ayes have it. Clause 9 stands part of the bill. Clause 10.
Section 42A inserted.
Honorable Haruna Idrisu.
Mr. Speaker, clause 10, I beg to move that the following new subsection be added. The principal enactment is amended by the insertion after section 42 of, with a head note, report to Parliament. The special purpose vehicle shall submit reports annually on its operations and act Parliament through the fund. Mr. Speaker, just to emphasize that there still must be accountability for Parliament to exercise oversight, because the fund is given some mandate to the special purpose vehicle to perform some functions on its behalf. My initial difficulty, even with clause 10, was that it is seeking to oust the Public Financial Management Act. If you read 10 well, the principal enactment is amended by the insertion after section 42 of the application of enactment. And my difficulty is, why do we want to say that the special purpose vehicle shall have no accountability or effect with the Public Financial Management Act? If that be the case, then we should provide another layer for us to report so that we can police our operations and activities. I understand that the majority leader improved upon the text earlier today. I shall submit. Thank you.
Honorable Chairman.
So the SPV, would be a creation of the fund. So why don't we further amend your reporting to Parliament to read the fund shall submit reports annually on its operations and activities to Parliament? Because
Yes,
including activities, so the emphasis on the fund by including activities of the SPVs, so that my proposed rendition would be that the fund shall submit reports annually on its operations and activities to Parliament, including activities and operations of the SPVs. Your leader says it's fine. Your leader says it's fine.
Yes, Honorable.
Mr. Speaker, I support the present amendment, save that I don't think it is necessary for us as a house to say its operations and activities. We should simply say the fund, so that it will read the special purpose vehicle, or in the words of Chairman, the fund shall submit reports annually on its operations and activities to Parliament through the fund. But yes, but no. Leaders are to the effect that the special purpose vehicle, the Chairman is further amending it to read that the fund, rather, and I want the SPVs to also be captured. Very well. Very well.
think that has been taken care of. Very well. Yes, Chairman.
Mr. Speaker, we want to further amend to take out operations or activities like so that the fund shall submit reports annually on its activities and administration, consistent with Article 103 of the Constitution. Activities and administration to Parliament, including activities and administration of the SPP.
Thank you very much.
Mr. Speaker, I want to take it again. The fund shall submit reports annually on its activities and administration to Parliament, including activities and administration of the special purpose vehicle.
All those in favor say aye. All those against say no. The ayes have it. And the question is that clause 10 as amended stand part of the bill. All those in favor say aye. Those against say no. The ayes have it. Clause 11.
Section 43 of Act 978 amended.
Chairman.
Mr. Speaker, clause 11, opening phrase, line 2, before of insert on first occurrence. So that clause 11 now reads, where the offense committed is by a body corporate, that body corporate is liable on summary conviction to a fine on first occurrence of not less than 750,000 penalty units and not more than 3 million penalty.
Honorable Yechi.
Mr. Speaker, I support the amendment because this is the penalty issue. So the first occurrence is what should count in this particular case.
Honorable Majority Leader.
Mr. Speaker, I've read the original 43.4, which provides where the offense committed is by a body corporate. That body corporate is liable on summary conviction to a fine of not less than 750,000 penalty units, not more than 3 million penalty units. I thought you were really going to correct that. I meant the units instead of units. I believe so. Let them take care of that. The 4, the last word, unit, should not units, penalty units. Mr. Speaker, I believe what they have proposed to insert on first occurrence really refers to 43.5, which is listed as 43.4.
Yeah, there was a repetition. That one too has to.
So you rather correct the second 4
Second for the correct.
as 5.
Yeah.
But Mr. Speaker, what is provided there reads, a fine imposed under Section 4 that is not paid when it is due shall attract an additional penalty of 5% of the original amount for each day of default. Mr. Speaker, I believe 4 already is clear enough without adding on first occurrence. A commission is a commission, a default is a default. And 4 says that when a fine is imposed and is not paid, thereafter any single day would attract an additional penalty of 5%. You don't need to insert on first occurrence in 4. I don't see the relevance in the amendment.
Chairman, therefore, final rendition.
The Speaker, the majority leader says I have to abandon my amendment. The majority leader says I have to abandon my amendment.
Would the honorable majority leader then give us?
The
Honorable majority leader, please give us the full rendition.
The servant is not bigger than the master.
Honorable majority leader, can you give us the full rendition?
Mr. Speaker, the chairman was proposing an amendment which seeks to insert in 4 the words on first occurrence in line 2. Mr. Speaker, in that regard, 43.4, the original will now read, where the offense committed is by a body corporate, that body corporate is liable on summary conviction to a fine on first occurrence of not less than 750,000 penalty units and not more than 3 penalty units. The Speaker, I'm saying those words we don't need. They are superfluous. They are superfluous in the sense that when you say that they have committed the offense is committed once. A penalty is imposed. Now, he has failed to pay the penalty. And he says that to the extent that the penalty is not paid, any additional day attracts 5%. It doesn't mean a repetition of the offense. That is not what it means. If it means a repetition of the offense, then it will make relevant what they want to insert on first occurrence. So, Mr. Speaker, there are 2 different things, and that's why I'm saying that we don't need the amendment being proposed by the chairman.
Honorable Leader.
Mr. Speaker, if the leader can address this issue, in 43 of the Act, Section 43, incidentally, they have numbered the subsection 4 and another 4, which life. So if he should refer to which 4 he's referring to. Leader, you will listen. In the 43, there are 2 4s, subclause 4. I mean, subsection 4 and subsection 4. It is the second one.
It's the first one.
Is the first.
So that's the second 4.
You see, the new 5 is because we have 2 4s there. So when you look at it, which one are we amending? If it is the first one, where the offense committed is by a body corporate, that body corporate is liable on summary conviction to a fine of not less than 750 penalty units and not more than 3 million penalty units. Then for the second 4 says, a fine imposed under subsection 4 that is not paid when it is due shall attract an additional penalty of 5% of the original amount for each of the. So, unless the chairman can tell us which of the 4s were they trying to amend, the first 4.
Yes, Honorable Majority Leader.
Mr. Speaker, the amendment being proposed is to the original 4, the first 4. And I'm saying that we don't need the words on first occurrence. We don't need it at all. And it's because if you do that, it will mean that the meaning of the second 4, now to be the 5, relates to a second commission of the same. But it's not like that. Really, it's a default in the payment. You are supposed to pay this. You don't pay it, then if there is an additional day, it attracts 5% of the penalty imposed. It's not a commission of the sin the second time. So we don't need the words on first occurrence. That's the point I'm making.
The Speaker, amendment abandoned.
The amendment. VI as an amendment is abandoned. VII also on clause 11. Chairman.
The Speaker, Roman 7 on page 20. Clause 11, amendment proposed. Add the following new subsection 5. So, Mr. Speaker, this 5 would have replaced the original 5, which was the original second form. So now that will be the new 5. So a fine imposed under subsection 4 that is not paid when it is due shall attract an additional penalty of 5% of the original amount for each day of default.
I know the same thing. Mr. Speaker, I would just advise the chairman. There's a second form, so he only needs to tell us that the second form, the numbering should change to 5, because before we come to 5, subsection 4, the second form really should be subsection 5. So we only need to change the number 4 in the second form to 5. Because he has just repeated those words. And we don't need that. So just tell us that the amendment is to change the second 4 to 5. And it's the same construction.
Chairman.
Speaker, the amendment is to change the second 4 to 5.
Yes, Honorable.
Speaker, safe to say that I agree with that. Safe to say that we can delete it is in second line. So a fine imposed under subsection 4 that is not paid shall attract an additional penalty of 5% of the original amount for each day of the default. So we delete it is when it is.
Chairman. Honorable Yerichire.
I agree with the further amendment, and also to say that the original amendment really should have been renumber subsections to make the second subsection 4 subsection 5. That should have been the amendment proposed. But that, so it's now been done, and I think that when due, rather than it is
When due.
yes.
So, Chairman, what is the final position?
Mr. Speaker, the further amendment that he proposed.
So, say the fullness, considering the original and the further.
Now we will read a fine in subsection 4 that is not paid when due shall attract an additional penalty of 5% of the original amount for each day of default.
I put a question. All those in favor of the proposed amendment say aye. Those against say no. The ayes have it. And the question is, clause 11, as amended, stand part of the bill, and all those in favor say aye. Those against say no. The ayes have it. Clause 12.
Section 45 of Act 978 amended.
There's no amendment here.
The question is that clause 12 stand part of the bill. All those in favor say aye. Those against say no. The ayes have it. Any further clauses?
Mr. Speaker, if you can go to the long title.
VIII, long title.
An act to amend the Minerals Income Investment Fund Act 2018, Act 978, to clarify the parameters for the operation of the Minerals Income Investment Fund and to provide for related matters.
Honorable Chairman, your proposed amendment, please.
Mr. Speaker, the table read out the long title. You read the long title. There's an amendment proposed in the long title. Yes. The long title. Mr. Speaker, long title. Amendment proposed. Line 2, delete fund and insert fund, comma, to authorize special vehicles to operate as regular commercial companies.
Those who have points, please feel free to be on your feet. We are arguing from our seats. Yes. Oh no.
Mr. Speaker, thank you. Mr. Speaker, I support the present amendment, save that we just litigated the use of entity. So I believe that instead of merely saying commercial companies, we could say commercial entities.
Honorable Chairman, please, are you in tune with the honorable member on the floor?
I thought he was going to.
Honorable, don't think what he was going to do. Just listen to him for now.
Mr. Speaker, I had moved an amendment, and is he further amending a further amendment to which is that we just litigated and succeeded with the use of entities. So I believe that instead of merely saying commercial companies, we should rather say commercial entities. So that companies, the use of entities will be taken care of by the use of companies.
Honorable Chile.
Mr. Speaker, thank you very much. The chairman is saying that after the funds, to authorize, indeed there should not be any comma, because he's deleting and provide for. So what we should now say, wait. Provide to authorize special purpose vehicle to operate as a regular commercial companies. But I think that, as my colleague is saying, this is an entity, it's not typically a company. So we can replace that to operate as a commercial entity and for related matters, which is also the amendment superimposed on this. You will say a fund to authorize special purpose vehicle to operate as a regular commercial entity and for related matters.
Special commercial entities. You prefer entity to company? Yes, Honorable.
Speaker, entity and singular, not plural.
Chairman, are you advised?
Mr. Speaker, we can. Okay.
Yes, sorry, Honorable.
Speaker, Honorable Electre was trying to explain the further amendment. But I heard him say, as a regular, the A is not there. So I don't know why he said A. It's regular entities. The A should not come in at all.
Honorable.
Mr. Speaker, I said a regular entity because I want to make the entity singular. That's why I said so.
A regular entity. And we abandon company. The Honorable Yirichi, you rather that we abandon commercial entities?
And we are drafting in the singular. Of course, the singular includes the plural. So I'm saying that to authorize a special purpose vehicle to operate as a regular commercial entity.
Very well. As a regular commercial entity.
The Speaker, the amendment being proposed reads thus: that is, fund to authorize special purpose vehicles, and the vehicles is plural, to operate as regular commercial companies, or as you are now agreeing, entities. Now, if you singularize the entity or company, then you have to go up. And then the special purpose vehicles, you have to also singularize the vehicle. If you do that, it will then sink. Other than that, you can't hype off the commercial entity and make it singular, while the special purpose vehicle is plural. So, Mr. Speaker, that is one. But I think we need to think through the regular commercial entities or companies. We need to think through. We need to think through.
Thank you very much, Mr. Speaker. Mr. Speaker, the long title, as said in the other paper, doesn't give us the true meaning of the intent of the bill. Because, Mr. Speaker, the line is saying we are inserting a fund to authorize special purpose vehicles to operate as regular commercial, the amendment that they are proposing. If you set up a special purpose vehicle, it's for a specific activity. So it doesn't exist in perpetuity. Companies exist in perpetuity. That's why they have a going concern concept. So you can say a special purpose vehicle as a commercial company in perpetuity. We set them a specific agenda. When they are done, then they go off. What we are saying is that we want to put in place a special purpose vehicle in perpetuity. That's the meaning of setting up a special purpose vehicle. We set them up for a specific purpose. When they achieve their aims or objectives, it doesn't exist any longer. So, they are one now. So we can't contemplate as if they will not achieve the purpose for which they are setting them up.
Honorable Chairman, therefore, Honorable Dr. Akutu will say.
Mr. Speaker, I stand to be corrected. I'm not a lawyer. But my good friend got up that companies are set up in perpetuity.
To say that?
To say that companies are set in perpetuity. And I need to be educated. I don't know which law or which laws say that companies are set up in perpetuity. I don't know where he's coming from. I know he's going to law school, but he needs to educate us. You know, this cannot be. Mr. Speaker, I want to agree with the majority. I want to agree with the majority leader. Because we use special purpose vehicles up there, I think we should leave it as regular entities, not as a regular entity. Then it will be consistent.
Thank you. Yes.
Mr. Speaker, thank you for giving me the opportunity just to help the minister. A company has a perpetual succession, but a special purpose vehicle is not for perpetual succession. So that is where Honorable Achampong is arguing from, that we set up a special purpose vehicle is for specific purpose and for a period when the project is ended. That is the end of the special purpose vehicle. But if you are talking about a regular commercial company, that regular commercial company is supposed to have a perpetual succession in terms of a company, speaking about company.
Mr. Speaker, I think the only point of disagreement here is whether to couch this in the singular or the plural. And if we went back to, then it would be to a special purpose vehicle to operate as a regular commercial entity.
So we want to maintain entity.
Yes, so that in line 2 to it.
And then we'll go back and do the relevant amendment.
Purpose, a special vehicle, also in the singular.
Thank you. All those in favor, yes, sorry. Honorable Adaku.
Mr. Speaker, the chairman needs to guide the House specifically on this. My colleagues have already suggested to him. Special purpose vehicles have narrow and specific time-related existence. They are not regular entities in terms of companies. You should be able, if it's an SPV, it should even have a termination point. You cannot have an SPV that exists forever. So, Mr. Speaker, I can see to the extent that we are even saying SPVs. So, an SPV have got a narrow agenda. So when you say SPVs, for instance, what are they supposed to be doing? What are those entities? So, Mr. Speaker, it would be difficult for us to just pass this without clearing this issue. If you want to set up a company, it's different. But SPVs, by their nature, even if you Google it in law, in project management, it will tell you the difference between ordinary companies and SPVs are such that SPVs have narrow, specific existence. And reasons for their establishment must be known from the beginning, and even termination point. Mr. Speaker, Parliament can form an SPV with somebody else to do something, but it cannot exist as an entity forever. So, Mr. Speaker, the chairman needs to be clear on this, and it's not English language. SPVs by law. What do you want to establish? A company that exists as a company or an SPV for a specific purpose? We need to, and to change it to SPVs, Mr. Speaker, for me, we are getting into a territory that we may pass something, but in reality, its interpretation may be problematic, Mr. Speaker. We need to get this understanding clear. What is the definition of SPV in this law?
Chairman.
Mr. Speaker, Honorable Mesa wants to come.
Honorable Mesa.
He's behind the pillar. He's close to the pillar.
Yes, Honorable.
Thank you, Honorable Speaker, for the opportunity. Speaker, I think that the rendition as proposed by the chairman is appropriate because the provision itself recognizes that SPVs are not regular companies. But for purposes of this act, we intend that to the extent that they exist, they operate as regular companies. So that's why this provision is being proposed. So I think it's...
Why for purposes of this act?
The Speaker, the provision is saying
for
that...
what reason are we deviating?
SPVs, because they lack perpetual succession, are not regular companies, strictly so-called. But in the performance of their operations under this act, SPVs are to be deemed to operate as regular companies or entities. That is my understanding from position that
the Speaker is proposing for the long title.
For the purposes of this act, we are creating a new test for SPVs. Very well. Yes.
Mr. Speaker, I think I support the proposal made by my good friend who just spoke. Mr. Speaker, I would have even thought that the amendment from companies to entity is not necessary, because the special purpose vehicle, by the discussion we have had, is an entity already. And the amendment that the chairman is seeking here is that they would operate as regular commercial companies. There's nothing wrong with that. With a company may have succession, long succession, but it doesn't mean that a company would stand treaty. It may run as long as you want the company to run. And that is why I do not think that the amendment as proposed by the chairman should be touched. Entity, special purpose vehicle is already an entity. But we are being specific here to say that they would operate as regular commercial companies. And to me, this is straightforward, and we should not touch this. Thank you. Mr. Speaker, I believe that when we gather to enact laws, we are guided by other protocols. Mr. Speaker, international commercial regimes that govern even SPVs. So we cannot, as a house, be saying that we want to set up a strictly speaking a commercial entity and call it an SPV. That is why the chairman should be very clear. If he's communicating government policy, he should say so expressly in the laws that we cover. If he's setting up an SPV, the international commercial regime is that it's for a specific purpose for a period. So we cannot be crafting laws to detract from that regime. That's my humble opinion. If it's a commercial entity we want to set up to even operate offshore, we can say so in the law. We don't necessarily have to label them SPVs to let them appear so. So the use of the SPVs is what is creating the problem for us. We have the power. We have the power to create an entity to serve our purpose, whether domestically or externally. But as soon as we say SPVs, it means there are legal underlying principles within which they have to operate. And that is why we appear to be running into some difficulties.
Let's listen to first of the speaker.
Thank you, Mr. Speaker. Mr. Speaker, I'm trying to understand what the controversy is. We have provided a meaning for SPV in clause 12, subclause E. The special purpose vehicle means an entity created to receive minerals income allocated by the fund under an allocation agreement. It's an entity we have created and called a special purpose vehicle. It is different from what you have conceived. When people create other ones they give them names, but they have other titles. Somebody is called Kantanka. That is his name. But he creates a vehicle and calls the vehicle Kantanka Omama. It doesn't make him a human being. It is a Kantanka, a vehicle he has named Kantanka, or a vehicle he has named Buafo, or even Toyota. Toyota, I'm told, is a family name, right? So we have created an entity by law that we are called special purpose vehicle. We should distinguish that from the special purpose vehicle we know. If we have that confusion in our minds, let's please disabuse our minds. This one is created by law, and it is a name. Special purpose vehicle is a name given to the entity we have created. It's not the same thing as other. When people create other special purpose, they give it names. So the description is different from this one we're doing. I thank you, Mr. Speaker.
Honorable Yerichi.
Mr. Speaker, thank you very much. The purpose, the special purpose vehicle, as we do, once you set it up, you always define its parameters, how long it can stay. When it has achieved its objective, it dissolves. So the issue of the operation now, we want to regularize their operation. The current one we have created in Act 978 subjects them to a specified way of doing things. Now, this bill is being brought so that we will allow them to operate almost outside the PFM Act, so that they can borrow, they can do things like any commercial entity. So that is why. But if they remain in essence SPV, which means they are not there in perpetuity. No. If you set it up and allow it to operate as a commercial entity or company, whatever you want to say, you are exempting it from the limitations that 978 imposes. And so the main purpose of this amendment of Act 978 was to allow SPVs set up under the fund to be able to do other things regularly not done and come under the Companies Act or PFM. If you look at the amendment that was proposed by the minority leader and further amended by the chairman, they said that these acts will not apply and mention the PFM Act and then the other acts which relate to that. So the purpose, the argument is not about they being a company or we are setting up a company. No, it is that they are now going to be allowed some elbow room, be able to borrow or do other things, just like a company would do. So either we accept the principle or we reject it. But I think that if it is, the purpose is to allow them to operate, it doesn't convert them into companies.
When in a law, the law or act itself defines a particular word, you must interpret it for purposes of that law as so defined. Does the law, the proposed law, interpret entity? If it does, do we have any difficulty? Honorable Majority Leader.
Mr. Speaker, I believe the amendment proposed by the chair really is to give the signal that the special purpose vehicle is to operate in the framework of commercial companies. What does it mean? That we should be guided by sound commercial principles or sound business principles. So if we want to avoid this whole debate, why not perhaps say that instead of saying to operate as regular commercial companies, or people are proposing that we delete regular and have commercial companies or entities, we could just say to authorize special purpose vehicles to operate on sound business principles and to provide for related matters. Mr. Speaker, I believe that it will kill this whole argument because it is just to guide us that we are to operate on sound business principles. And that to me is good. If we do that, it will help us a lot.
Yes.
Mr. Speaker, I think I agree.
Honorable Member for Adaku. And then Honorable Minority Leader. And then we'll vote. Okay.
Mr. Speaker, I think Majority Leader has provided some opportunity for us to resolve this. Partly because, Mr. Speaker, when the first Deputy Speaker was trying to guide us, his explanation rather made it problematic because if you see the interpretation,
he's reacting.
I am reacting to Mr. Speaker. You see, my senior colleague, if we don't get the understanding, it is not about rushing into this. Has become an issue to be dealt with. Mr. Speaker, if you see the definition of a special purpose vehicle, B, Mr. Speaker, it talks about a parent company. Mr. Speaker, parent companies set up subsidiaries called SPVs. So if you are defining SPV to be a parent company, it is quite problematic. We need to resolve. That's why I'm saying that if what Majority Leader is saying is that for the purpose of sound financial management, we are creating the, then let's find the appropriate word to define that specific understanding so that we are not saying that we are creating SPV to go and do anything commercial because the purpose must be specific. But exactly. And we may have to come and redefine the definition in B, which EB, which says that a special purpose vehicle can even be defined as a parent company. That cannot be. A parent company sets up SPVs. A parent company cannot set up another parent company of its own. It can only be a subsidiary. There can only be one root of a company. Thank you very much, Mr. Speaker.
Minority.
Mr. Speaker, I agree with the reasoning of the Honorable Kwame Agboja that is a mineral development fund which is giving birth to this special purpose vehicle. Therefore, we do not need to turn the walking stick in respect of who gives birth to the other. It is the mineral development fund which is creating the special purpose vehicle. My understanding is that, and as the Majority Leader observed, this special purpose vehicle must operate on sound commercial principles in order that, as I understand further, government wants to use this vehicle to leverage using the royalties or collateral of mineral development as guarantee to borrow money. If that is the reasoning, then what leader have advised, since with the memorandum, if you come to clause 3, the board will procure the services of asset managers to manage the assets of the fund. It is not going to be the usual SPV we know of. So we should marry the two observations. Leaders' observation that the long title incorporates sound management principles and be guided by what the Honorable Kwame Agboja suggested, that it cannot be the SPV which is giving birth to the Mineral Development Fund. I thank you, Mr. Speaker.
Honorable Chairman.
Mr. Speaker.
Honorable Majority.
Mr. Speaker, I think the colleagues have brought into what we need for the non-title. And the other one that is being raised by the Honorable Abuja, Mr. Speaker, I believe that is also valid. We then will have to look at the definition of the special purpose vehicle, that it means a parent company. That will be what we have to re-engineer. We have to look at that. And I think once we have some agreement on the long title, Speaker, we can always go back to that one and take it.
Chairman, are you in a position to resolve this for us?
Yes, so the long title, as further amended by the majority leader, is to delete fund, and it said fund to authorize a special purpose vehicle to operate on sound business principles. Well, you are bringing the commercial again. On sound business principles and to provide for related matters.
Chairman, we are waiting a final rendition.
The final amendment is that in the long title, the amendment proposed in line 2, delete fund, and instead fund, comma, to authorize a purpose vehicle to operate on sound business principles. And to provide for data, which is already there.
To operate on
sound business principles.
On sound business principles. Very well. It appears acceptable. All those in favor say aye. Those against say no. The ayes have it. And the question is that long title as amended stand part of the bill. All those in favor say aye. Those against say no. The ayes have it. Chairman.
Mr. Speaker, if we can accommodate the concerns of Honorable Kwame Abuja, so if we can go back to the interpretation section and look at the definition of special purpose vehicle again.
Interpretation. Honorable.
Right, Honorable Speaker. Myself and my colleagues went through the discussion on that. I believe the clause 12 EB.
No, A first.
No, A is okay. No, Mr. Speaker, A. Even we need to do a little amendment on A. Mr. Speaker, A says a special purpose vehicle means an entity created to receive mineral income allocated by the fund under an allocation agreement. That is fine, Mr. Speaker, but that is not all that the SPV is supposed to do. It's also supposed to invest and administer that soundly, as majority leader guided us in the sub. So, Mr. Speaker, if we can add at the end of to receive and administer minerals income allocated by fund under the allocation agreement. Yes. So they are not only receiving, they are also administering that fund, which we are all. Mr. Speaker, B ought not to be there at all. We need to delete B completely because the intention of this vehicle is captured entirely in A. So we are proposed that we delete B because it is it will not add anything, rather make it, in fact, it's turning the concept of SPV upside down. So if colleagues will agree, we delete E, B entirely and just amend A slightly to include and administer income allocated to the fund under an allocation agreement.
So that finally it will read?
Special purpose vehicle means an entity created to receive and administer minerals income allocated by the fund under the allocation agreement.
Thank you very much. Yes, Honorable.
Mr. Speaker, the present proposed amendment will serve the purpose of this bill.
You support the amendment?
So I support that.
Thank you very much. I have a question on the amendment. If Honorable Majority.
Yes, Speaker. Yes, Speaker. I've just looked at the original definition of special purpose vehicle in the Act. It provides, it means an entity created by the fund to receive minerals income assigned by the fund, that is, of course, in the allocation agreement, and into which investors may invest or for the purpose of a joint venture. What is wrong with this? I thought that one was even tidy. The allocation agreement is to receive minerals income assigned by the fund, and it's done pursuant to the allocation agreement. So I don't really see how you came to amend that. There's no need for an amendment. If you want the allocation agreement, you could just say it means an entity created by the fund to receive minerals income assigned by the fund pursuant to the allocation agreement, and into which investors may invest or for the purpose of a joint venture. That is it.
Honorable, I can see you are in support. Honorable Majority Leader, shall you give the final rendition then?
Mr. Speaker, I said what obtains there in the Act, we could maintain it. And just because of the terms of the allocation agreement, you can just import the words allocation agreement here, so that it will read, a special purpose vehicle means an entity created by the fund to receive minerals income assigned by the fund under the allocation agreement, and which investors may invest or for the purpose of a joint venture.
All those in favor of the amendment say aye. Those against say no. The ayes have it. And that the bill amended accordingly. All those in favor say aye. Those against say no. The amendment stands part of the bill. Yes, Honorable Minority Whip. Chief Whip.
Thank you, Mr. Speaker. Mr. Speaker, I will just crave your indulgence and that of the House. And since we are still at the consideration stage, if you permit me to take you back to 1A, the amendment that we did. Sorry, clause 3.
Clause 1.
It's clause 1. 1A.
Clause 1.
Yes, clause 1A, where we amended to say that the fund will hold direct or indirect equity interest in a special purpose vehicle in any jurisdiction in furtherance of the objects of the fund. Mr. Speaker, if you look at the original rendition, it was just talking about create and hold equity interest. So the danger of putting the direct and indirect, Mr. Speaker, my want to propose is that we delete the direct and indirect. Mr. Speaker, the danger with the indirect is that you create a special purpose vehicle that will go and use your own money and give it to another person to lend it to you. But if it's direct, you know that every money that, say, I've given to company X is going to be invested into company Y, and therefore prevent company Y lending that money, my own money, to me at an interest. But when you say indirect, what you mean is that, say, I have equity in Well by Smith, and then Smith, Well decides to take Smith's money and invest it in, say, another company where Ghana is going to lend money from. You will not be able to see the money that it is your own money that is being. So if you allow the indirect to stay, that is what will be happening, because then you not have control over exactly what your money will be used for. Because you yourself have said in the law that it could be done directly or indirectly. So, Mr. Speaker, I was hoping that if we could delete the indirect, that would have made it perfect so that you can track your money wherever it goes, because clearly the fund will not allow anybody to take our money and reinvest that money in us or lend that money to us. So my proposal is that clause 1A, line 1, delete or indirect, so that the new rendition will be hold direct equity interest in a special purpose in any jurisdiction in furtherance of the object of the fund, and each special purpose vehicle shall, even though I've seen that it's been deleted, shall operate as a regular commercial company. I so move, Mr. Speaker.
Chairman. Originally, it was in the Act, the fund may hold equity interest. Over there, it could be direct or indirect. They hold equity interest in the Act. So this is just clarifying that it could be direct or indirect. Because in the Act itself, where you say that the fund could hold equity interest, where does it say that it cannot be indirect? It could be direct or indirect. Actually, what is missing here in the amendment is that the punctuation, the comma after the hold must go. The first comma after hold. It is to hold direct or indirect equity interest. Mind you, we have come back here because the fund in creating SPV has been speaking investors, and this is some of the concerns that they have. They don't want the situation where government is directing the SPV in what to do. So that's why the SPV on its own is going to have its own board. You understand? You don't want this to be subjected to governmental control in all instances. That's why you have the fund on the SPV. And we have even gone further to say operate on sound business principles. Okay? And when we're moving the amendment, Honorable you were here. Now you have come us back to clause 1. I was even signaling to you that we need the amendment. So please. So is the punctuation, Mr. Speaker? That has to the comments. The comments should just go, but you just want to expand on this to say that it could be direct or indirect. If you didn't have it there, it doesn't prevent the fund from having indirect interest. So this is to expand on it.
Thank you, Mr. Speaker. Mr. Speaker, if my colleague is saying that the original rendition means they can do direct and indirect, why do you now want to put it there? Because, Mr. Speaker, what I'm saying, we know a lot of international companies do this. They come, they take your money with one hand, and on your blind side, redirect to another company, and you go there to lend. To prevent this, that is why you need to have your eye on. I was trying to get a rendition where, in this very act, that says that money from this fund cannot be what do you call it? Lend. If you cannot lend that money to our country again. Yes. But when you say indirect, the special purpose vehicle can choose to put that money in another company who do not know, and that company will lend money to you. But when you say direct, the person will not be able to do it without you knowing, because you will have to know exactly what's happening with the special purpose vehicle at all times. But when you say indirect, it exonerates the special purpose vehicle from you doing exactly what they do, because you are saying that indirectly they can invest your money.
That's why now the minority leaders amendment mandates the SPV through the fund to report annually to Parliament. So annually, the SPV through the fund will be reporting to Parliament. Originally, in the Act and also in the amendment bill, that requirement was not in there. But now, they would have to report annually to Parliament. So whatever the SPV is doing, and by extension the fund, we would know.
Well, Mr. Speaker, if our colleague is saying that whatever they'll be doing will be known to us, and our money cannot be taken and used through a special purpose vehicle and lent onto us. Mr. Speaker, as you know, the court proceedings now use even deliberations in the House. So having had this comment in our records, it means that in future, no special purpose vehicle can operate and use our money for on us. So if he says that's what it means, I will leave the federal amendment to have, since it's in our record that that's what the chairman is saying.
But in the amendment effected here today, the SPV is free to lend to whatever entity. It's rather the fund that cannot lend to government. But in the amendments that we have effected today, and that is in clause clause
1042.
Yeah, on the other paper, sorry. On the other paper in clause 10. On page 19. Clause 2. The fund shall not provide credit to government, a public enterprise, a private sector, or any other person. Originally in the bill, it was the fund or SPV. And now we deleted the SPV and said now the SPV is free to do so because they're operating on sound business principles. And furthermore, in clause 10, on the other paper, Roman 5, there you have the minority leaders amendment, which was further to say that now the fund shall submit reports annually on its activities and administration to Parliament, including activities of the SPV. You see, some of these are not captured on the other paper because they were further amendments. And confer with your leader.
Mr. Speaker, the chairman has just confirmed my worry. How can a purpose vehicle take our money and lend it to us? Mr. Speaker, it's not done anywhere in the world that you put your money to a purpose vehicle and then the special purpose vehicle then lend the money to you at an interest rate. No. Mr. Speaker, Mr. Speaker, let's get it right, because these are royalties and equities from the minerals that have been exploited in our country. If you create a special purpose vehicle and you put that money, you are expecting that special purpose vehicle to invest that money in areas that will yield dividend to you. Now, with what the chairman is saying, it confirms my original reason why we should not allow them to do direct and indirect transactions without on our blind side. Now he's confirming that we deleted the special purpose vehicle so that we can allow the special purpose vehicle to unlend monies that we invest there to us again. There's everything wrong with it. There's everything wrong with it, Mr. Speaker. This is our mineral income. You take our mineral income and lend it to us. Mr. Speaker, no. That is not right.
Honorable Dr. Kutose. Honorable Dr. Kutose, the chairman.
Mr. Speaker, I know that my good friend came after all these amendments have been made. But what he's trying to say is that that SPV could lend to anybody else on a sound financial principles, but not to the government. Anybody else, even a cocaine dealer, we allow them to lend to them, and we don't want to allow them to lend to us on a sound financial basis. That is the criteria. And you have to keep that in mind, because if it's going to lend to you, but it cannot lend to me as a government, there's a problem. That is the essence of this SPV, so that they can operate on a sound financial basis or commercial basis. Because the lending will be looked at on this merit. On this merit. So I think it's important that we keep that in mind. Otherwise, it cannot do that. The fund cannot do that. The fund cannot do that, but the SPV should. That opportunity.
Chairman.
Speaker, I think there's agreement now. And so if we can, having finished the long title, it is because of your magnanimity. Yeah. We are still here. Otherwise, you should be coming under second.
No, Honorable, that doesn't matter. If there's gravamen in the matter, let's talk it. Do you agree or you are not? In the final analysis, I'll put a question. After all, the honorable member can come by second consideration even if you were not here today. Honorable Minority Chief Whip.
Thank you, Mr. Speaker. Mr. Speaker, if you look at the original proposed amendment on page 6 of the committee's report, you will see that it was there. The fund or a special purpose vehicle shall not provide credit to government or a public enterprise. And I'm saying that even the proposed, the originators of the bill recognize this. And now we have amended it to allow the special purpose vehicle to be able to do that. We should be mindful of the danger in that.
Mr. Speaker, I think we are mixing up issues. The issue that we first brought relates to the original clause 3 or section 3, which provides the fund may create and hold equity interest. It may create and hold equity interest. Now we are saying the fund cannot create any equity interest. They can hold. So we are deleting the create. And so we have the fund can equity interest. Now if you leave it as it is, you delete direct and indirect. It's the same thing. They can hold it directly or indirectly. So what they have done here is just for purposes of emphasis and clarity. Nothing has been added, nothing has been subtracted. The figure that is it. But having said so, the issue of they having to operate on sound business and commercial principles, it struggles the whole body of the bill, of the act. The figure, if you go to 2, what we just did, section 4 of 96 Act 978 amended, it provides they operate in accordance with sound commercial principles and shall use the best endeavors of the fund to ensure that each special purpose vehicle operates in a similar manner. So all through, we have emphasized this, that they should be operating on sound business or commercial principles. So, Mr. Speaker, we have not introduced anything foreign to the original, except to make it much more clearer.
I think we better abandon this at this stage. Otherwise, we can put a question on it. Honorable Minority Chief Whip.
You've already put a question on the long title.
Nobody.
You already put a question on the long title, so we are coming out of consideration stage.
No, we can go forwards and backwards. I have a flexibility, and I would like to apply it. It's up to Honorable Muntaka to abandon the proposed amendment, or we put it to the vote.
Mr. Speaker, the actual bill, the original bill that has been amended, Act 978. Speaker, if you read 4.3, in the performance of this function, the fund or a special purpose vehicle shall not provide credit to the government, public enterprise, private sector entities, or any other person or entity. This is the current act. they have not told us why they want to exempt the special purpose vehicle. Because the qualification that the majority leader,
your proposed amendment is that
the special purpose vehicle be included in the exception, so that it will read in the performance of its function, the fund or the special purpose vehicle shall not provide fund as it is in the current act. Because in the current act, what they are talking about, prudent management, is also there. Because if you read 4(2)(b), it says, operates in accordance with sound commercial principles and shall use its best endeavor to ensure that the special purpose vehicle operates in a similar manner and it moves on. So those clauses were already here. So it's not that by excluding the special purpose vehicle in lending to our state, that's when now we are adding that they will operate with commercial and what have you, commercial endeavor and what have you. It is already there. And Mr. Speaker, the simple reason is that I don't give my money with you to invest, and then you turn around and give the money to me at a higher interest rate. It doesn't happen.
Thank you very much. Yes, in opposition to the proposed amendment, Honorable Dr. Kuto said,
I'm a bit worried about my good friend's intentions. First, he took us to 3A, about direct and indirect. Now, he's going to 4.3. Next time, he may go to 5.5. Mr. Speaker, we've gone through all of this, and the arguments have been made earlier. He was not here for all the time. But if you allow him to take one section one by one, it will lose meaning as to what the bill is supposed to be. So I want to plead with my colleague. If we do that, we will be here all day. Because very soon you go to 9A. But we have gone through all of that. The issue has been settled. So please, let's
Thank you very much.
progress.
All those in favor of the proposed amendment say aye. The amendment, very well, the amendment proposed by Honorable Muntaka. No, we've gone a long ways, but we want to settle the matter. Yes. All those in favor of the proposed amendment by Honorable Muntaka say aye. All those against say no. The no service. The amendment has been, the proposed amendment is defeated. Honorable Chairman, any other matter for consideration? Order.
Mr. Speaker, this brings us to consideration stage.
Thank you very much. Order. Honorable members, this brings us to the end of the constitution stage. The first Deputy Speaker will take the chair. Honorable Majority Leader, where do we go from here?
Mr. Speaker, we'll deal with the order paper addendum 2. Order paper addendum 2.
Order paper
addendum number 2.
Addendum number 2.
Yes.
One, presentation of papers. A. I. By the Honorable Foreign Minister for Finance.
Mr. Speaker, the Minister for Monitoring and Evaluation can do on behalf of the Minister of Finance.
Yes.
Loan agreement between the government of the Republic of Ghana, represented by the Ministry of Finance, and Israel Discount Bank Limited, for an amount of $74,120,000 United States dollars, including ASHRA's premium of $6,120,000 United States dollars, to finance the supply of armored vehicles to the government of Ghana.
The agreement is duly presented and is referred to the Finance Committee for consideration and report. Aye.
Commercial loan agreement between the government of the Republic of Ghana, represented by the Ministry of Finance, and Israel Discount Bank Limited, for an amount of $12 million United States dollars, to finance the supply of armored vehicles to the government of Ghana.
The report is duly presented and is referred to the Committee on Defense and Interior for consideration. On Finance for consideration and report. B, the Honorable Minister of Defense.
Contract agreement between the government of the Republic of Ghana, represented by the Ministry of Defense, and Elbit Systems Land Limited of Israel, for an amount of $80 million United States dollars for the supply of armored vehicles to the government of Ghana.
The paper is duly presented and referred to the Committee on Defense and Interior for consideration and report. C, Chairman, Finance Committee. Chairman, the report is ready? It is not ready. Very well. Honorable Majority Leader, where do we go to?
The Speaker will deal with the addendum order paper, the first one.
Addendum?
The one. Addendum order paper, the first one.
Very well.
Addendum 1. Motion. Yes, Honorable Chairman.
I rise to move that this Honorable House adopts the report of the Committee on Foreign Affairs of the Host Country Agreement between the Government of the Republic of Ghana and the African Union for the establishment of the African Continental Trade Area Secretariat. As Speaker, in so doing, I present your committee's report. I intend to limit myself to a few paragraphs and the conclusion of the report, and I invite the Hansa Department to do the needful. I'll capture the entire report. Speaker, regarding the settling in cash grants of $10 million for the Secretariat's operations, the committee was informed that the amount was not paid upfront to the AU Commission, but was to be released and when a request was made for the preparatory works and program of the Secretariat. Speaker, on financial impact, the committee observed that there are substantial financial obligations and responsibilities for the Government of Ghana in hosting the AFTA Secretariat. The committee noted that per Article 3 of the agreement, Ghana is required to provide secured, equipped, and furnished permanent premises at its expense for the Secretariat at its headquarters in Accra. Article 5 further requires the host country to provide, among other things, secured, equipped, and furnished official residence of the head of the Secretariat
Article 6 enjoins Ghana to provide a settling in cash of some 10 billion US for the After Secretariat to commence operations. Speaker, in conclusion, the establishment of the Secretariat in Ghana will enhance the country's leverage and influence on the African continent and the world at large. It will also facilitate the effective execution of the AFTA, which seeks to deepen the economic integration of the African continent by creating a single continental market with free movement of businesses, people, and investments. The projected benefits of the agreement are significant. The Secretariat will serve as a framework for the implementation of the decisions of the states of the African Union. Speaker, the committee is satisfied that Ghana's and that the agreements are in line with the host country agreements in other African countries hosting AU organs, and therefore recommends to Parliament to approve the agreement by resolution in accordance to Article 75 to your resolution. Thank you, Speaker.
Yes, Honourable.
Thank you, Honourable Speaker, for the opportunity. Honourable Speaker, I stand to support the motion. Honourable Speaker, the committee had the opportunity to visit the Secretariat for the African Continental Free Trade Secretariat. And, Honourable Speaker, we were very impressed with the job done on behalf of the government of Ghana. And I would actually like to singularly congratulate our dynamic and affable foreign minister for the good job done. You only need to go and see the Secretariat and you'll be proud of what Ghana has achieved. I think they have the minister, the Honourable Minister for Trade and Industry, who conducted us around the Secretariat, was one of those who played a big role in bringing this Secretariat to Ghana. Not only at the time we visited the Secretariat, everything was in place. In fact, when I say everything, even the residence of the Secretary General to be, I am very convinced that if the Secretary General arrives in that residence, he must seek another 4 years after the end of his term. Because it's so salacious that I'm sure he wouldn't like to retire after the first 4 years. Honourable Speaker, I think the benefits of bringing the Secretariat to Ghana are clear. And we were told also, because the committee was quite concerned about the $10 million commitment, that we were told quite categorically that disbursement has even started. And there are what we call reimbursements based on accounting for what has already been spent. So we are quite comfortable that the Secretariat is willing and able to take off. That Honourable I so support. Thank you very much.
Honourable Minister for Estate.
Thank you very much, Mr. Speaker. Mr. Speaker, we are all very glad for this report, and we are all happy that very soon the operations of this Secretariat will commence. Mr. Speaker, the establishment of the Secretariat clearly shows that when you have a president that promises and delivers, you are sure that whatever he says will be done. Mr. Speaker, this trade agreement is a very huge one. In fact, it's the second largest trading bloc after the WTO, 0.2 million Africans. The value for this potential is over 1 trillion. And currently, as a country and as a region, we're in a very small part of it. In fact, Africa is only doing about 150 billion worth of value in trade. And clearly, this agreement, which this secretariat is going to, we are sure to go to $1 trillion US dollars. Mr. Speaker, I believe that now that it is here in Ghana, it is time that we look at how we can take full advantage of the proximity of this secretariat to our country. We've talked about the financial impact of this agreement. In fact, when you look at the secretariat and the 10 million we are going to spend, it is peanuts if we really take good advantage of the proximity of this secretariat in our country. Mr. Speaker, the report also talks about employment opportunities for Ghanaians. And I'm very happy that it's insisting that we look at a quota system for Ghanaians that will be employed at the Secretariat. Mr. Speaker, it's very, very important. It is very, very important. When we do that and ask for that, it helps us to prepare our people to fill in these vacancies as quickly as possible. Instead of just anyhow and very difficult to control and monitor. So, Mr. Speaker, I believe that it's good that the committee has been able to identify this particular situation. In concluding, Mr. Speaker, if you take paragraph 5.5, the last paragraph of that place, it says, the ministry informed the committee that the security agencies responsible for diplomatic protection has been notified and that they have been given the assurances of the provision of adequate security and protection for the premises, the residents and officials of the Secretariat. Mr. Speaker, this morning, we've been told that Ghana is the third most peaceful country in Africa. And I believe that in getting the security agencies to give the necessary protection to these people, and the rest, will go a long way to sell our name out there and also be able to attract good investments into our country. But talking about investment into our country, I believe that Ghanaians, this is the best time to take our economic development very, very, very seriously. Because it's this little economic development that will help us export and trade with other parties in other parts of the African continent and create value and money for our people so that we can take away the poverty that seems to sweep all our regions in the African continent. So with this view, Mr. Speaker, I do believe that this report should be supported by each and every one of us and to give confidence to the African Union that Ghana is ready to do business with Africans in the world. Thank you very much, and may God bless us.
Yes, Kumbungu. Thank you, Mr. Speaker. Mr. Speaker, mine is as short as an old lady's dance, as the minority leader relishes to say. Mr. Speaker, if you look at the establishment of cities, our peers in East Africa have taken the shine from us. East Africa is hosting all manner of international organizations. Ghana being the gateway to Africa, we should have been at the forefront of hosting not just AFTA, but many other international organizations looking at our reputation as a country. So even though it comes late, but it's better. And I believe this provides us an opportunity to make further cases to host such international organizations within our country. Finally, Mr. Speaker, on recruitment. If you look at countries that are hosting such institutions, many of their nationals populate some of these things. So even though the African Union has its own recruitment criteria, we should encourage a lot of our nationals to apply for positions in this particular organization when, an announcement is made for recruitment. I know that the Secretary General has already been appointed. There's a vacancy for a Deputy Secretary General, and there's a vacancy for advisors and the rest of it.
it is important that Ghanaians take it's important that our Ghanaians take advantage of it. So, Mr. Speaker, I thank you, and I also recommend for the approval of the committee's report. Thank you very much.
Yes, Honorable.
Thank you very much, Mr. Speaker. Mr. Speaker, it is very, very good and an opportune time to commend the Foreign Minister and the Trade Minister for this wonderful job that they've done for this country. Most importantly, the President for leading the charge during the campaign towards the establishment of this Secretariat in Ghana. Mr. Speaker, last week your committee visited the Secretariat, and I must say that it's a very beautiful office, beautiful Secretariat, well set up according to the AU standards. And I must, Mr. Speaker, with the leave of the Foreign Minister, recommend that every member visits the Secretariat to understand what this Parliament is approving today. Mr. Speaker, let me refer you to paragraph 5.4 of the committee's report on the commencement of operations, which has delayed. It was supposed to have started from the 1st of July 2020. We are in August, and it's been postponed to the 21st because of COVID issues. My plea to the hardworking Foreign Minister is to take some steps to ensure that special arrangements are also made for this, the Secretary General and those important officers who can come and help with the commencement of the operations of the Secretariat, because we have to go. The heads of state are meeting, I believe, in December, on December 5th, on this very important issue, and I think it's worth calling or asking the minister to put in place special arrangements. Mr. Speaker, this is also very important for the creation process on the African continent. My colleague from Takoradi mentioned the blockers, the second largest in the world, 1.2 billion and what have you. Mr. Speaker, there are other benefits to the good people of Ghana in terms of recruitment of local staff, and we must take advantage of. Secondly, there will be a lot of conferences in Ghana. Are we ready? Are hotels ready? Are car rental companies? Other hospitality industries or companies must also get themselves in readiness or put themselves up to bid and undertake some of these activities. Finally, Mr. Speaker, the government made a pledge to the President of a $10 million settling in grant. And I must commend the Trade Minister during the briefing that the government is adhering to all the procurement processes in procuring all the facilities or equipment necessary for the setting up of this Secretariat. It's a good day for this House, and the Minister is here in accordance with Article 75 to ensure that the hosting agreement is approved in accordance with our Constitution. I thank you very much, Mr. Speaker.
Honorable Minority Leader.
Mr. Speaker, let me thank you for the opportunity to contribute to the motion by the chairman of the Foreign Affairs Committee on the African Union and the Continental Free Trade Agreement. Colleagues have contributed, and it's true that since the creation of the World Trade Organization in 1995, this is the largest single trade agreement. But, Mr. Speaker, there are some worrying issues. Whilst I like to note and recognize the role of the Minister of Trade and Industry, Honorable Alain Chimanting, and Minister for Foreign Affairs, and even the President, in getting Ghana to host this important Secretariat. Because my first observation is one, we need to find out why initially Nigeria and South Africa were reluctant to sign to this agreement. because on the whole, there are two major players. Even as I speak, I'm not too sure whether South Africa have signed on to the agreement. They have not been able to ratify it for what they call technical reasons. So, because, Mr. Speaker, some of them have argued that this can affect and undermine local businesses. And Mr. Speaker, just to share some statistics, at the end of 2016, intra-Asia trade was between 59 to 69%. Africa was 18%. It leaves Mike to be desired. Intra, just Asia, trade among countries in that region was between 59 to 69%. Africa was only 10%. Mr. Speaker, if you come to take global trade generally, the contribution of Africa is at 2.6% at the end of 2017. So nothing to celebrate. Global trade, overall 100%. Africa has only increased from 2.4 to 2.6% as at 2017. So, but I recognize that the potential is Africa and the future is Africa. That is why Ghana must take full advantage. I understand that the secretariat hosting it was initiated in 2013 and 14 under the NDC administration. Indeed, I initiated what is now called the Ghana Exim House or Ghana Export House, which is proudly holding the CFTA together with the Ghana Exim, which at the time was the Ghana Export Agricultural Industrial Development Fund. And Mr. Speaker, another potential, having created the Ghana Exim, to what extent have we used it to support and increase the export volumes and regimes of our country? We still are a dependent import country. That is not good enough. Then, Mr. Speaker, my conclusion. It is one thing demonstrating that we are proud hosts, and it's another thing keeping the values of true Africanism and Pan-Africanism. As we are speaking, some shops of Nigerian businesses have been locked down in Ghana, and Ghanaian businesses cannot penetrate the Nigerian market. So where is our sincerity as African leaders and African heads of state? And Mr. Speaker, my worry, Nigeria still has a long list of what they call prohibited goods from Ghana. There are certain categories of goods that Ghana cannot export to Nigeria. Yet we open our markets to them. I can understand the closure of the shops is within the law. I think that some provisions were made under the GIPC Act to protect our own. But the sincerity of our African leaders to open up is important. Look at Dangote. We facilitated his presence in Ghana here. We gave him all the incentives. Can a Ghanaian company boast of presence in Nigeria? So what's the sincerity that intra-African trade? He can come here, we create a opportunity for him to do business. Same must be given to Ghanaian businesses that want to be able to do business in Nigeria. I'm not satisfied with the level of intra-African trade. And Minister, they say charity begins at home. We are not in this country developing very good private sector entrepreneurs to drive the growth of the Ghanaian economy. But I wholeheartedly support this. And then Ghana, as I heard Honorable Ras Mubarak and Patrick, Secretariat is not a Ghanaian secretariat, it's an African secretariat. Therefore, its opportunities must be open to all of us. I thank you, Mr. Speaker.
Yes, majority leadership. The minister will want to make a comment before.
Thank you, Mr. Speaker. I rise to thank members for supporting the motion on the floor, which has to do with the ratification of the host country agreement of the African Continental Free Trade Area Secretariat in Ghana. Mr. Speaker, I'd like to place on record our appreciation to the select committees of affairs and trade. They have been committed in supporting government to operationalize the Secretariat, and we are very grateful for that. Mr. Speaker, we are happy that the AU process from inception to the signing of the AFTA agreement and the host country agreement today has ended up in Parliament, and is opening the door for the Secretariat to start operations. Mr. Speaker, the Secretary General and his team, the first team to kickstart operations, will arrive in the country sometime. Indeed, it is true that we had to postpone it from March to August, and also even the operations of the Secretariat, the trading has been postponed to January. But we are, and we believe that this will happen very soon, despite the delays that have been caused by the COVID-19 pandemic. Mr. Speaker, AFCFTA it's already been said on the floor, that's the largest trading in the WTO, made up of 55 member states with a market of 1.2 billion people and a combined GDP of almost 3 trillion. Mr. Speaker, this affords us a great opportunity for Africa to take its rightful place where trading is concerned. Indeed, it is a fact that intra-African trade is woefully very unimpressive if you compare it to what happens in Asia and in other places. So we are very happy that this is happening, and for Ghana to host this Secretariat, I think that we need to take advantage of all the opportunities that it presents us. The host country agreement, Mr. Speaker, will provide us with an agreement for where our obligations are concerned, and also the African Union obligations. But in our obligations, Mr. Speaker, we are supposed to provide the office space, which we have, 4 floors at the Trade House. We provided a residence for the Secretary General, and also we granted diplomatic immunities and privileges to the full diplomatic immunities and privileges to the AFTA Secretariat, its staff and its dependents. Also, members have already talked about $1 million settling in grants, which is basically to facilitate the speedy establishment of the Secretariat. So far, some disbursements have been made upon requests that have been presented to Ghana by the Union Commission. Some of the requests have been cost to reconfigure the Secretariat to the taste of the Secretariat to be able to deal with the needs of the Secretariat in terms of its functioning, also security to make sure that the premises is well secured. Also, the funds recruit the Secretary General was provided, and also his travels and his cost of stay in Ethiopia. Since March, he has been domiciled in Ethiopia, and so that has all come within the 10 million settling in grants, Mr. Speaker. Mr. Speaker, also as part of our obligations, we will be providing the Secretariat with technical expertise from MDAs such as Customs, Ministry of Finance, Ministry of Foreign Affairs, Ministry of Trade. This is a group of people who will help for 6 months in the setting up of the Secretariat as a support team. Mr. Speaker, in terms of potential benefits, there's a great benefit for Africa as a whole, but also for Ghana, we know that there will be great benefits because the Secretariat is here. It will employ about 200 people from all over Africa, and as has been said by the minority leader, this is open to all member states. So there will be no quota system in terms of the core staff. However, in terms of local staff, in line with the AU practice, the host country citizens and residents will be employed. And mainly junior level general support staff positions, short-term professional staff to provide them technical support. It would include drivers, janitors, management professionals, secretaries, translators, consultants, and others. And we are estimating the local staff strength to be between 100 and 150 people. So that I believe is quite appreciable. Hosting of the AFCFTA also would have several economic benefits. It would positively the hospitality sector, and it will also provide us with it would also help us in the development of our conference hosting and associated support businesses in this country. Mr. Speaker, so this whole endeavor is an endeavor that we will definitely benefit immensely from. And so I'm happy that the comments from the floor have been very positive in that members are supporting the motion for the approval of the agreement, for the Secretariat to come into being. Thank you, Mr. Speaker.
At the conclusion of the debate, the question is all in favor of the motion, say aye. All against, say no. The ayes have it. The motion is carried. Item number 2, resolution by the Minister for Foreign Affairs and Regional Integration.
Thank you, Mr. Speaker. Mr. Speaker, I beg to move that this August House adopts resolution number 2 on the addendum order paper. I so move.
Yes, Chairman of the Committee.
Speaker, I rise to second the motion.
Honourable members, the motion to adopt resolution number 2 on today's order paper addendum is been moved and seconded. All in favor say aye. All against say no. The ayes have it. The House has adopted resolution number 2 on today's order paper addendum. Yes, Honourable Majority Leader.
Mr. Speaker, if you can go back to the order paper, addendum 2. I think we left a couple of matters there unattended to. Has to do with 1C and 2. Order paper addendum 2.
Addendum order paper 2. Item 1C. All right. Well, Chairman of the Committee, yes. Honourable members.
Reports of the Finance Committee on the suspension of the fiscal responsibility rules for the 2020 financial year.
A report is duly presented for distribution to members.
Speaker, the Minister for Monitoring and Evaluation can do two on behalf of the Minister of Finance.
Item A on the addendum order paper.
Item 2.
2.
2 on the addendum order paper. Addendum 2.
Very well. Item 2. Presentation and first reading. Honorable Minister.
An act to establish the National Insurance Commission to provide for the regulation and supervision of the insurance market and for related matters.
The bill is still presented. It's referred to the Committee on Finance to consider and report. Yes, Honorable Majority Leader.
Mr. Speaker, I want to plead for us to take the motion listed as item number 5 on page 5 of the original order paper.
Item number 5. Motion. Education Agency Bill. Is that right? Yes, by the Minister.
Mr. Speaker, the Minister for Education indicated that he wanted to do this himself. Unfortunately, he called a few moments ago to indicate to me that he's indisposed and pleaded with me that I do so on his behalf. If you don't mind, I can do the...
Very well.
I move the motion. Mr. Speaker, I'd like to move that the Complementary Education Agency Bill 2019 be now read the second time. Mr. Speaker, the object of the bill is to establish the Complementary Education Agency to provide for educational programs outside the formal education system. Mr. Speaker, the Constitution in Article 25D provides that functional literacy shall be encouraged or intensified as far as possible. Mr. Speaker, Article 38, sub 3 obligates the state to provide, subject to the availability of resources, a free adult literacy program and lifelong education. Mr. Speaker, the Complementary Education Agency aims to provide learning opportunities and complementary education for those who are outside the mainstream Ghanaian education system, to equip them with the requisite knowledge, skills, and attitudes needed for their personal, community, and national development. The name is changing from the non-formal education to complementary education to reflect the myriad of changes that have taken place in the area of non-formal education, and to acknowledge that complementary education can be formal and recognized within the qualifications, a set qualifications framework. The Speaker, the non-formal education division of the Ministry responsible for education has been in existence since independence. The division has been providing a range of programs relative to adult and lifelong education. However, the government wants to ensure access to education in all forms. Therefore, it has been necessary to enact legislation to establish an agency responsible for complementary education to ensure the carrying out of the myriad of changes and innovations taking place in the field of complementary education. Mr. Speaker, it is for this reason that this bill is being introduced to the House to enable the House assist government in providing a well-structured edifice to oversee the implementation of this new program of government, and indeed which is being done pursuant to Article 25, Clause 1, Subclause D, and Article 38, Clause 3. The Speaker, I do so move.
Yes, Chairman of the Committee.
Thank you, Mr. Speaker. Speaker, I rise to support the motion moved by the Majority Leader. So, Speaker, in doing so, I read excerpts of the report, of my report, sorry, the Speaker, of your report, of your committee's report, and plead with the Hazard Department to capture the entire report as having been read. So, Speaker, the background to this agency has been given by the Majority Leader, and so I go on to mention the highlights of the bill. So, Speaker, the bill is made up of 37 clauses and divided into 7 sections. A, establishment of the Complementary Education Agency. B, governance of the agency. C, administration of the agency. D, financial provisions. E, organization of complementary education. F, decentralized complementary education. And G, miscellaneous provisions. Speaker, several observations were made that are amply captured in the report. The report has been distributed since morning, so I guess my colleagues have read it. Mr. Speaker, in conclusion, we say that Ghana's quest to empower its citizens to participate actively in the economic life of the country and contribute meaningfully to the governance process can only be fully achieved through an education system that promotes inclusiveness, equity, and designed to meet the specific needs of citizens, particularly those outside the formal education system. Without doubt, the establishment of the Comprehensive Education Agency, sorry, Mr. Speaker, this is, I think, should be a complementary, not comprehensive. Maybe if you can make that amendment. Without doubt, the establishment of the Comprehensive Education Agency is an important step towards the overall development of the country. The complementary education program will ensure that no citizen, no matter their circumstance and the community, in which they live, is left behind in the provision and acquisition of knowledge, skills, and lifelong learning opportunities, make them more functional and self-reliant for decent livelihoods. Against this background, it recommends to the House to approve its report on the Complementary Education Agency Bill 2019, especially submitted, Mr. Speaker.
Yes, Honorable Ranking Member.
Thank you, Mr. Speaker, for the opportunity to support the motion for the second reading of the Complementary Education Agency Bill 2019. Mr. Speaker, at the time of independence of this country, we know very well that the literacy rate was very, very low. And majority of our people did not have the opportunity to go to school before that time. So President Kwame Nkrumah, on becoming the leader of government business and the president of Ghana, decided to introduce what we call then mass education under the Department of Social Welfare, so that those who were unfortunate and did not have formal education could have the opportunity to read and write. So this agenda was pursued vigorously. As a child then, I remember how very well it was organized. And in my village, I remember very well, we called them a night school. And people were in charge of that, especially teachers in those communities were made responsible for mass education. And I can say that as a result of this mass education, my father was able to read and write
as someone who had never been to formal school, and that made even his business grow. Mr. Speaker, I can also say that I had the opportunity to sit in the classroom in the teacher training college with a gentleman who went through this mass education and was able to join us in the formal educational system and became a teacher, went and did his degree in basic education and retired as an assistant director of education. Mr. Speaker, this opportunity was there and it made it possible for people to learn and write, especially market women who were able to do simple mathematics and all those things, how to keep money for various records and purposes. But with time, Mr. Speaker, this mass education changed into non-formal education, and it also continued with the work that was done by the Department of Social Welfare. Later, it was brought under the Ministry of Education, and that's where it has been for a very long time. But what we have noticed is that in the last few years, this division has suffered from less funding. Because of less funding, they are not able to function very well. Because they have been subsumed by activities of the Ministry of Education, and no immediate or urgent attention is being paid to them. So now they are under functioning as a division. It will be very important to know that although our literacy rate has gone up and more people can read and write, we still have people who are out of formal educational system and who need to be helped by this agency. So, Mr. Speaker, it is my hope that when this agency is created, it is not going to be a white elephant which will not be funded adequately. Because as we speak, the department is very, very deprived. They don't even have official vehicles to go around and see how their district directors and others are doing. It's my hope that if it is, this bill is passed, much or enough budgetary allocation will be made to the department or the agency for them to function very well. On that note, Mr. Speaker, I support the motion. Thank you.
Yes, Honorable Regional Minister.
Thank you very much, Mr. Speaker. Mr. Speaker, when I was a young man, I asked myself, what was the purpose? Okay, when I was a boy, it makes it easier. What was the purpose of informal education? Then I asked myself was that non-formal were teaching people our basic language, but there was nowhere in the world or in Ghana that you see even signboards or advertisements written in our local language. But non-formal education, Mr. Speaker, as we have all come to know, has been a major provider of functional literacy. Education that makes our people fit and work with society. In fact, one of the beautiful things I've seen about this complementary educational agency bill is in the memorandum. And paragraph 3 of the memorandum, it says, the complementary education agency aims to provide learning opportunities, complementary education for those who are outside the mainstream Ghanaian education system, to equip them with requisite knowledge, skills, and attitudes. So, Speaker, the interesting part for me is attitudes.
Sorry,
one of our biggest challenges.
Honorable members, having regards to the state of the business of the House, I direct that we sit outside the regular sitting hours. Yes, you may continue.
Thank you. It's attitude. Mr. Speaker, we all know that you can have all the knowledge, can have all the skills, but if your attitude of being committed to your work contract is not correct, you will never be a success. And that is where I'm so happy that the minister and the committee have been able to prepare this document for second reading so that they'll be considered at the consideration stage. Mr. Speaker, lifelong learning is very key. I do remember in those days, my grandmother used to ask us where they were having this non-formal education. But because consistently they were not having good budgets over a long period of time, they couldn't organize these classes as consistent as they should have doing so. I've seen that and heard from the ranking member talking about budgets and being neglected because they have always been subsumed by the Ministry of Education and its agencies. Mr. Speaker, but that when you have a government that believes in the capability of its own people, consistently it will make effort to invest in this project. We are all aware that this year we've been able to make provision of 5 pickups and 2 land cruisers as a government through the non-formal educational unit. And with the passage and with the decentralization that we are envisaging for this bill, I know that if they stand alone as a strong entity, as an agency, Ministry of Education, naturally, they will get enough budget to support their activities. Mr. Speaker, one of the issues that has also been raised is the fact that the CSOs, civil society organization, for a very long time, have played a huge part in that space, in that complementary educational space. Because, like we're all aware, African governments for a very long time have not been so strong to occupy all the social spaces in our country. And therefore, by the committee's own recommendation, that the board of this complementary educational agency should include members from the CSO who have been in this space forever. The bill also proposes to validate and accredit complementary educational actors. And I believe that is a good way to go, because in this space we have a lot of private sector actors, and we need to continue to encourage them by regulating them properly so they can feel safe to invest, they can feel safe to expand, and they can feel safe to know that whatever they are doing will be validated by government. So when somebody takes a certificate from these private or non-formal educational arrangements, they are sure and very sure that whichever certificate they take anywhere, it will be recognized. Speaker, that has been one of our major challenges. That most of the time, because a lot of those taking those policy decisions have gone through the formal arrangements, the recognition for the non-formal sector tends to be a big problem. And now that we have an agency that can validate and accredit these programs, I believe to go a long way to engender more people for lifelong learning. And in doing so, when they are able to work within such framework, then they are sure that whichever certificate they hold, non-formal education, or now, as we are going to call it, complementary education, is also going to be recognized anywhere, and they'll fit into society and play their part to make Ghana greater and stronger. Thank you very much, Mr. Speaker.
Yes. Thank you very much for giving me the opportunity to contribute to the second reading of the Complementary Education Agency Bill 2019. Mr. Speaker, a lot has been said about the object of the bill being that this particular bill will provide the opportunity for those who couldn't get opportunity in the mainstream education system in Ghana to be able to or to be. Mr. Speaker, the bill is just changing the name of non-formal education to Complementary Education Agency. Mr. Speaker, it is good that we establish an agency to be responsible for a complementary education, otherwise can be referred to as a non-formal education. So, Speaker, since a lot has been said about the object of the bill, which is very good, I intend not to go over it. So, Speaker, it is observable that the bill is establishing regional and district directorates. The bill is going to lead to the appointment of regional and the district directors with the parliamentary staff. Mr. Speaker, all this would have a financial implication. My worry is that we have passed the Public Financial Management Act, which enjoins us to fiscal impact analysis for all the legislations introduced in. Mr. Speaker, consistently, Parliament, we've been flouting this particular law and this particular bill that we are considering at the second reading. There is no fiscal impact analysis of the bill. So, Speaker, if I may read Section 100 of the Public Financial Management Act, it is clear. It's on the head note, fiscal impact analysis of legislation and proposals. And it reads, any legislation to be laid before Parliament or proposal submitted, approval of Parliament shall be accompanied by fiscal impact analysis stating the estimated effects on revenue and expenditure for the financial year in which the legislation or proposal is expected to come into effect. Speaker, 102 states the fiscal impact analysis shall be prepared and submitted in accordance with the regulations. So, Speaker, this is a bill that will have a financial impact on us as a country. But there is no fiscal analysis to know this is the revenue or expenditure impact of the bill. Mr. Speaker, it is not good that this House will pass a law but will be persistently and continuously flouting its own law. It's not the best. I believe strongly when a procedure is set down for a right to be exercised, it is only right learning that that procedure should be followed in exercising that particular right. Therefore, I'm bringing it to the fore of the House that we should ensure that the laws that we passed are obeyed. Therefore, as Parliament, we must ourselves respect and obey our laws that we pass. Mr. Speaker, having stated that the object of the bill is very clear, I cannot be opposed to the stage of this particular bill into law, but agree that this particular bill should be passed into law. Mr. Speaker, with these few words, I support the report of the committee that be adopted by the House, and then the bill expeditiously should be passed into law so that people who do not have the opportunity in the mainstream education will also be given the opportunity under the complementary education so that they will have the requisite knowledge and be well equipped in the society for the development, for their personal development, as well as the development of the various communities that they will be coming from. I thank you for giving me the opportunity.
Yes, Honorable.
Thank you, Mr. Speaker. Mr. Speaker, I rise to support the report on the Constitution. First of all, Mr. Speaker, there is a cliche that states that education has no end. And indeed, this bill epitomizes that. We are looking at a situation where people who didn't get the chance for education to be given some basic knowledge and skills to help themselves and the community. And then I think that anything that will annul to this particular policy is a welcome news. I commend the ministry for bringing such a bill. The Speaker, complementary education program, the report indicates that it's going to be designed to fit for purpose, which means that in itself, the program will ensure that education, non-formal, becomes utilitative to the individual and the community. In other words, it is going to be tailored along such lines that a community that we have seen a particular challenge, how do we enhance and mobilize things in such a way that the very things that are their means of livelihood, courses are going to ensure that people who will benefit can actually apply what they've been taught. The third thing that I see about this bill, the Speaker, the report, is that as a House must gradually also take serious consideration to the fact that it's always not an end in itself by approving loans both in the various sectors. For example, such an education, if we relate it to a BRIC, will enhance our rural community. Simple implement which has been imported into the country. If Ministry of ABRIC liaises with the various district assembly to provide such an education, basic knowledge of do's and don'ts on the use of a particular implement, basic measurements when you are going to apply an insecticide. Most of these are rural folks. Sometimes are handicapped when some of these things that we bring into the country, even reading basic measurement becomes difficult. And I think that a policy will help. Finally, Mr. Speaker, I think that mostly the organizers are going to deal with adults. It's critical and important that by teaching them, they take cognizance of methodology and how to impact the requisite knowledge into them. You can imagine somebody who is about 50, 60 years old, and then a young guy of about 20 years going to, teach such a person. If care is not taken, even the impact of the knowledge into such a person, carefully, they will see it as something that is a bother to them. And so, yet, these are very good policies that are going to benefit communities and those who didn't get formal education. Mr. Speaker, like the report indicates, the governing body and those implementers at the base level will take cognizance of the fact that they are going to deal with people who are adults, who may not grasp some concept as fast as the youth will grasp. And so we will only caution that we also handle it in a manner so that at the end of it all, the objective of the bill, the purpose for which this bill is being brought for us to endorse, will be achieved. Mr. Speaker, with these few comments, I urge the House to adopt the committee report and ensure that passed. Thank you for the opportunity.
Leadership.
Mr. Speaker, the Honorable Lecturer was indicating to me here, anyway, he says, Mr. Speaker, I will speak in favor of the motion that the Complementary Education Agency Bill be read the second time. But in doing so, Mr. Speaker, my first question is, what is in the name? Why are we changing the name from non-formal education to complementary education. Growing up as young minister, if you were going even to cabinet to justify a bill, carrying the public along was an essential aspect. Communication plan. You want to have a new communication plan to go back to the Ghanaian people and tell them that setting up a complementary education unit when they are already used to and have accepted a non-formal education unit. I think that we should revert to the original. I mean, what you are doing is, and it's an established UNESCO principle, non-formal education, lifelong learning. But, Mr. Speaker, Ghana has made progress, and part of it you can attribute to democracy dividends. Since the promulgation of the 1992 Constitution and its practice, free compulsory universal basic education was guaranteed under the Constitution. At the year 2000, the literacy rate in Ghana was 57.9%. In 2018 or today is 79%. It means that more and more pursuit of those constitutional imperatives of free education have afforded more children to be in school and to be literate. So, Mr. Speaker, if you have non-formal education which was implemented, don't forget that it was because many of them did not have access to formal education. We've expanded educational infrastructure, whether under President Rawlings Kufuor, J.E. Mills, President Mahama, Nana Dankwa, hitherto even rural areas. In my constituency, left with just about 2-3 rural communities which probably cannot boast of a decent classroom block. Maybe Batlai, Parishia has just started. So it means in the rural Tamale, government has done well in terms of expanded infrastructure to provide for education. So yes, now for education is complementary, but should we call the law complementary education? I have a difficulty. I mean, you have to go back to communicate with the Ghanaian people to find justification to explain to them. They are used to and they know non-formal education. Now, Speaker, my conclusion will be to refer to Clause 9 of the bill, and then the correct of the bill. And Mr. Speaker, when you go to the functions, why 16 functions for education? Why? When we get there, we'll try and then fine tune it. So, Mr. Speaker, let me say, just when you come to the bill, you see functions of the agency. Then you have 16 functions. Why? And then you want us to accept all these as functions of an agency. Brevity is the way to go. When you come to 19 funds of the agency, Mr. Speaker, then they say this approved by Parliament. Then they go further to any other monies approved by the Minister for Finance. The Minister for Finance does not have any authority to approve any money for spending. It's Parliament. And why will you double state it? You say money is approved by Parliament, then go and say again, indeed, money is approved by Minister responsible for Finance. That's why Parliament exercises the power of the purse. We decide who should spend, not a Minister of Finance. And therefore should not be usurping some of these powers to a minister. It's not right. So when we come to it, I believe, Mr. Speaker, we can clear that. But I think that if there is nothing in the name, it should just be called a non-formal education. And then the senior deputy minister was whispering to me, why 2019 when we are in 2020 and in the November of 2020? With these comments, Mr. Speaker, I support the motion.
Yes, Honorable Chile.
Thank you, Mr. Speaker, for the opportunity to support the motion. So, to say that the bill really flows from our Constitution, the educational rights, and also educational objective established by the directive principles of state policy. Mr. Speaker, the bill also flows from SDG 4. Mr. Speaker, the SDG 4 also is also captured in the bill.
the SDG4 aimed at ensuring inclusive and equitable quality education and promote life learning opportunity for all. Mr. Speaker, the SDG 4.6 has it that all youth and substantial adults, including men and women, must be literate and numerate by 2030. And therefore, Mr. Speaker, this bill is captured such that we can be able to reach there. Mr. Speaker, we are not to leave any back. And therefore, this bill, if taken and implemented through the agency, Mr. Speaker, could improve on our degree of dependence on our internal potential to create scientific and technological knowledge. Mr. Speaker, the bill has also really captured how we could generate the knowledge to get to the people, how the knowledge could be acquired, how the knowledge could be absorbed, and how the knowledge could be communicated, and even trying a pathway to link those who are interested from the complementary level into the mainstream. In fact, this bill is trying to capture those who are outside our Ghana education service opportunity created. Mr. Speaker, like the minority leader said, we have had to reach areas in this country. No matter what we do, there are areas where it's becoming difficult to plant the normal education system that we have. A minority leader, the complementary education has been in existence. What happened was that sustainability became an issue because it was being funded by non-governmental agencies. Okay, and therefore sustainability was so key. UNESCO and other international organizations were also funding when the funding got to a halt. And therefore has seen the advantage of using the complementary education system than the non-formal system. In fact, there will be a lot of dynamic situations where the non-formal situation is not able to solve. So the bill itself, if you look at the memorandum, when we read the paragraph 3, I'm reading from line 6. The name is changed from non-formal education to complementary education to reflect the myriad of changes that have taken place in the area of non-formal education and to acknowledge that complementary education can be formal and recognized within the qualification framework. Mr. Speaker, if you come to where we're talking about clause 23 to 26, Mr. Speaker, you realize how, like I said, the bill has structured how we could really generate the knowledge and then continue from there. It's very important because I'm so much aware about the complementary system that had brought a lot of young people who could not have the normal system, quite in the normal system, and they were able to fit into the normal system at a certain stage. And that is where we are also proposing and saying that the agency should try as much as possible also to do that. Mr. Speaker, also, we have to develop a knowledge society. In fact, there are a lot of our elderly people who we are trying to make numerate, we are trying to make them to become numerate and literate. Mr. Speaker, when we are able to do that, what it means is that our elderly who are already master craftsmen, already in the system, master craftsmen who are not too numerate and who calculation and measurement becomes difficult, will be able to improve their skills, will be able to improve their ability to measure, and those who are master craftsmen to be able to measure well, quantify well, and enumerate such that they can improve on the quality of their product. Mr. Speaker, the problem we have in this country is finishing. We've been able to initiate, we've been able to innovate, but finishing is our problem, and finishing is massive
how to enumerate, how to calculate, how to be able to be literate, to read and understand, how to even do our own system of pricing, that somebody is able to price so well that he or she can make some profit out of whatever he or she does. So I think that when we are able to fine-tune this bill, such that whatever amendment will come with it, we will fine-tune it and move along with this bill, so we can establish that agency that will take cogent effort at making sure that we have the complementary education system, and to be able to link it to where we can link it to the normal system. It will be very good for this to ensure that we've developed a knowledge society to improve the mental health of Ghana. I thank you, Mr. Speaker, for the opportunity.
At the conclusion of the debate, the question is: all in favor of the motion, say aye. Against, say no. The ayes have it. The motion is carried.
An act to establish the Complementary Education Agency to oversee the administration of complementary education and to provide for related matters.
The Complementary Education Agency Bill 2019 is now read a second time. Yes, Honorable Majority Leader.
Mr. Speaker, we can item 6. Item number 6.
Item number 6.
The registration of births and deaths bill.
Yes. Registration of Births and Deaths Bill 2020 at the consideration stage. But I'll suspend sitting for 5 minutes and come back. The House is suspended for 5 minutes.
Yes. Clause 7.
Registration assistant.
Yes. Amendment proposed. Chairman of the committee.
Speaker, thanks very much. Clause 7, amendment proposed. Subclause 1, delete and insert the following. The registrar shall designate a registration assistant in each zone in a district. I so move.
All in favor of the proposed amendment, say aye. I'll put the question again. In favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Item II. Chairman.
Clause 7, amendment proposed. Subclause 2, paragraph A, delete and insert the following. Inspect every household within the zone of each district to ascertain deaths, fetal deaths, and deaths. So move.
All in favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Item III. Chairman.
Mr. Speaker, clause 7, amendment proposed. Subclause 2, paragraph B, line 2, delete. Notification of. I so move.
All in favor of the proposal, say aye. All against, say no. The ayes have it. The amendment is carried. Now, clause 7 as variously amended shall stand part of the bill. All in favor, say aye. All against, say no. The ayes have it. Clause 7 as variously amended. That is to stand part of the bill. Clause 8.
Register of births and deaths.
Amendment proposed. Chairman.
Speaker, clause 8, amendment proposed as advertised. I so move.
In favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Item V. Chairman.
Mr. Speaker, clause 8, amendment proposed as advertised. I so move.
Amendment proposed to which subclause? Because we have already done one.
Amendment proposed for subclause 2 as advertised. I so move.
You have to delete what is there before you can insert what is advertised. Yes, Honourable Member for Huawei.
Yes, Speaker, I wanted to even go back to the first amendment he proposed, because I was going through, and what he says is that the registrar shall keep and maintain 3 national registers, namely National Register of Births, then he asks which record each birth. I don't think that which record which is running through all should be necessary, because each of these registers, the function is there. What is to be done is already in the functions. So there will be no need to be saying which record each, which we shall record death and all that, because in the main provisions, we know what these are to do. So adding this is superfluous. You can just say National Register of Births, National Register of Fetal Deaths, and National Register of Deaths without the additional which shall record these things, because that is not where to define the function there, or what should constitute the register.
Mr. Chairman, what's your position?
Mr. Speaker, this actually emphasizes the point. If you take each of them, it emphasizes the point that this register records this, so that we do not leave any ambiguity or leave anything out. So just for emphasis sake.
Yes, Achimda.
Mr. Speaker, I don't think it's necessary because these three types of registers are all defined. They are defined in the interpretation clause.
I can't hear you.
I'm saying they are all defined in the interpretation clause. The three types of registers, without that, better, they are all defined.
Yes, Honorable.
Mr. Speaker, the register does not record bets. It does not record bets. These bets, fetal deaths, and deaths are recorded at the lower levels, the zonal and district levels. And the register keeps the registers of the bets. So collection and collation of the registers of the bets from the whole country. So the National Register of Bets contains the record of each bet, and the National Register of Fetal Deaths does not record, but it contains the record of each fetal death. And also the National Register of Deaths contains the record of each death. So, Mr. Speaker, whilst I agree with the Honourable Member for West, that he is not the one who records the deaths, but that register contains the record, so that we capture it. But it's important that we have it, so that we know what the content is. So we should rather amend it. The National Register of Deaths, which shall contain the record of each birth. That is how it should be. The National Register of Fetal Deaths, which shall contain the record of each fetal death. The National Register of Deaths, which shall contain the record of each death. Mr. Speaker, that is how it should be.
Yes, Honorable Deputy Minister.
Thank you, Mr. Speaker. Mr. Speaker, indeed, if we look at the general rendition under Clause 8.1, the third line provides what we should capture. And if I should read the whole clause, it says, "There's established by this Act 3 national registers, one each for births, fetal deaths, and deaths, which shall be kept at the National Office of the Registry, and in which shall be recorded each birth, fetal death, and death in this country." So the amendment should be looked at in the sense that, as the majority leader said, the registrar doesn't record, but the registry he keeps, or registers he keeps, should contain what has been recorded. And the rendition here is "in which shall be recorded," or say "in which is recorded." But the "shall" is being used to ensure that indeed those registers should contain such information. So
let's go to the appropriate rendition. National Register of Birth.
Yes.
In which shall be recorded each birth.
Yes.
Or in which, yes.
Yes.
Mr. Speaker, what should be "which shall contain the record of each birth." Yeah, "which shall contain the record of each birth."
Very well. National Register of Births, which contain the record of each birth. The National Record of Fetal Deaths, which shall contain the record of each fetal death. And the National Register of Deaths, which shall contain the record of each death. All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, item V, same clause 8. You're deleting subclause 2 and substituting same as
Mr. Speaker.
Advertised.
Yes, as advertised.
I think the same amendment will go for this one as well.
Mr. Speaker, the same goes for this one as well.
So the proposed amendment is further amended as in accordance with the amendments voted upon in the item V. The draft persons are directed to consequentially effect those changes. So all in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item VI.
Mr. Speaker, clause 8, amendment proposed. Add the following new clauses as advertised. I so move.
Yes, all in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item VII.
Mr. Speaker, clause 8, amendment proposed, clause 2, line 2. Delete all the words after district up to the end of the subclause. I so move.
If you go back to V, subclause the following. So there's nothing. Am I right? But we delete tab clause 2, subclause 2.
Mr. Speaker, I agree with you. We try indulgence. We take this amendment out, please.
Very well. So, yes, Honourable Member for
Having deleted it, obviously they can be. And in fact, if you look at it, we have recast it earlier to take account of this, so there's no need to even move that motion again.
So clause 8 has variously amended, shall stand part of the bill. I'll say aye. All against say no. The ayes have it. Clause 8 as amended is ordered to stand part of the bill. Clause 9.
Community Population Register.
Amendment proposed. Chairman.
Mr. Speaker, clause 9, amendment proposed. Delete and insert the following as advertised. I so move.
Members, all in favor of the proposed amendment, aye. All against say no. The ayes have it. The amendment is carried. Now, clause 9 as amended shall form part of the bill. All in favor say aye. All say no. The ayes have it. Clause 9 as amended is ordered to stand part of the bill. Clause 10.
Power to accept affidavit or statutory declaration.
Amendment proposed. Chairman.
Clause 10, amendment proposed. Subclause 1, delete and insert the following as advertised. I so move.
All in favor of the proposed amendment say aye. Nobody is voting on this one, so I'll put the question again. All in favor of the proposed amendment say aye. All against say no. Yes, Honourable Member Fachimda.
Mr. Speaker, the clause 9 that we just did, Clause 2, sub-clause 2, a community may assist in the registration of births and deaths for the purpose of generating a community population register. Here, the key word here is a community may assist. And are they not going to assist in the registration of fetal birth? Just a question.
This is community population register.
But it can happen in the community and not at the hospital. If they are to assist, they can go and report. And that is assistance.
Yes, Honorable. We were considering clause
Yes.
10, and then you go back to clause 9 without notice.
Yes, we went to clause 9 to that. Mr. Speaker, I think the rationale behind this is the fact that for fetal deaths, they occur at particular locations and they have to be recorded. But for births and deaths, the community is to be involved in assisting in registering services. So that's why here the fetal death may not be featuring with regard to the births and deaths and the involvement of the community.
But clause 9 is not about register.
No, the 9 too.
You see, the whole clause 9
yes.
has been a district assembly shall maintain a community population register.
No,
and the community population register shall be used for demographic data for purposes of development planning of the district. The community may assist in, so that has nothing to do with the register of births and deaths. It's just population. I don't know whether it properly belongs here, but it's not about births and deaths.
The bill itself, community population register. 9.1 says a community registration officer may assist in the registration of births and deaths for the purposes of generating a community population register. So the births and deaths is captured here.
Honorable Member, go back to clause 9, delete and insert the following. So you have deleted the existing clause and you have introduced maintaining an assembly maintaining a community registration population register. I don't know whether it properly belongs to this.
Yes, Mr. Speaker. It's good that you've drawn our attention to it. It also means that we should have a reason why we want to delete the role of the community registration officer in the registration of births and deaths. Because it says if he may assist, but here the amendment doesn't capture that.
Very well. I should defer clause 9 for you to reconsider. Because
Chairman.
it's introducing a totally new subject.
Yes.
It's not related to that. So so let me proceed with clause 10. Clause 10, we are deleting subclause 1. Yes, Honorable Majority.
Mr. Speaker, I think when we met on days, we introduced another paragraph to 8. The original 8 had a community registration officer. And then we introduced another that had the community itself. It appears that one is missing. It appears that one is missing from the 9. Mr. Deputy Minister, one moment, I think we dealt with that. And even the one that has been introduced or has been mentioned by the Honorable Kwetu, that was also included. that a community registration officer may assist in the registration of bets. And we included fetal deaths and deaths. We included that. And then another paragraph in respect of community involvement. So, Mr. Speaker, it's good you are standing it down, but I just want them to that I think we created a subparagraph for 9, which involved the community's assistance.
Very well. So consideration of clause 10, clause 9 is deferred. We are considering clause 10. Yes, you have already moved the motion in clause 10, so it's for the consideration of the House. All in favor of the proposed amendment to clause 10, say aye. All against, say no. Yes, Honorable Deputy Minister.
I was just checking whether the best feature deaths and deaths will be in the original or it will be in the bill. I was looking at the singular and the plural. Because here it says for the purpose of registration of a birth, so that's singular. Feature death or death. I don't know whether those should be singular.
So, the singular includes the plural.
Plural. Okay.
Yeah. So as many as are in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item X, Chairman.
Mr. Speaker, clause 10, amendment proposed. Subclause 2, delete and the following. 1. The fees payable under subsection 1 shall be paid a bank account open for that purpose. I so move.
Do you want to propose that? That the fee for application or for whatever will be paid to the bank account of the Assembly before you come for the application? Or you are going to introduce a banker on site? That's another part of it.
Mr. Speaker, the bank account should belong to the registry. It should be the registry.
That's not even the issue. It's the practical application of this clause. If you come to Bekwai, there are 3 or 4 bank branches, but they are about 3 kilometers away. Each one of them is about 3 kilometers away from the district assembly offices. So you expect that applicants will go and pay to the bank and bring their paying slip or what? I think practically are going to have challenges if we don't review it. Yes.
Yes, Mr. Speaker, I agree with you entirely. For instance, if you come to South Dine, we have 2 commercial banks, Agric Development Bank, which is in Peve, and the commercial bank is in Peki, which is about 20 kilometers away. So what I think we can do as a house is to ensure that the office should have the capacity to receive these fees with appropriately issued receipts. Then they can, at the close of either business or the week, go and deposit into their accounts. And when it's time to audit, they can provide for the receipts of these monies. It will be difficult for the applicants to be going up and down, paying, meeting evidence of payment in the account before the application is processed.
Yes, let me listen to Chairman Fair.
Mr. Speaker, these fees we are talking about relates to late registrations. And then as the Electoral Commission does presently, when it's placed or you lose your card, you are required to pay into an account at a commercial bank, and then they process it for you. So I think we can have the same arrangement when it comes to this as well.
Do you know that some districts have no commercial banks at all?
Yes, Mr. Speaker.
Yeah.
I believe that the person registering should collect the money at that point and then send it as directed by the assembly or by the office of the registrar in the district. It shouldn't be the burden of the person coming to register to go and pay into the account before coming to register. It should be collected and deposited as required under financial rules.
Yes, honorable member.
Mr. Speaker, I think that the way it's put together presupposes that the bank will be at the same premises, like we do with the DVL and other places, where you say, go and pay to bank and bring it. But this is, you are going to deal with rural areas where they don't banks, for that matter. Apart from that, the person, you should pay a fee. That we are concerned about paying fee, and not what you do with it, where you keep the fee, because the fee administrative section, the registry will have accounts opened. And so the treatment they will give to the fee will be another matter, not the same person who is paying. He should go and pay into it. If you do that, it will be complicated. Just say that they should pay the prescribed fee.
Yes, honorable.
Mr. Speaker, really, I don't see much of a problem here. It says that for the purposes of registration of a birth, fetal date of birth, the registrar or district registrar may accept an affidavit or a statutory declaration of a person on the payment of a prescribed fee. Now, 2 then is saying the fees payable under subsection 1 shall be paid into a bank account open for that purpose. 2 does not put the burden on the person coming to do the registration. There's nothing here to indicate that.
If it is fees, it is already done. The revenue is a different thing.
Mr. Speaker, we have been making laws in this. If the burden is on the person, it will be stated here that the payment into the account should be done by the person. But as it is here, there's nothing. My understanding of this, it could also be on the person making the. In the same way, after it's been paid, it could be, or it must be lodged in the account. So I don't think that the burden necessarily is on the person paying the fee. It says that the fees payable shall be paid into a bank account open for that purpose. The district the registrar or whoever may receive the fee and then pay into a bank account. Yes, if it is that the burden is on that person, then we should be specific. But as it is now, I don't see that the burden necessarily is on the person effecting the payment.
Yes, far west.
You try as much as to avoid ambiguity. And this is ambiguity. Because if anybody takes the law and says, look, you have to pay this prescribed fee, but in the act, they say, go and pay in your account. Where is your bank account? That is why I'm saying we shouldn't create that. The purpose of this thing is that you should pay the prescribed fee. And what it is even stated in the earlier one, I don't see why we should even have this one here. Because if you say that for the purposes of the registration of all these, you can accept a person on payment or a prescribed fee, full stop. This is, the second is now going to have ambiguity as to who is the person to do that. And so we should avoid the ambiguity. That is what we are saying.
Yes.
Mr. Speaker, I want to suggest, instead of saying the fees payable, then we say the fees collected under subsection 1 shall be paid into an account open for that purpose.
But let's be clear. who do we want to pay? When you use fees, you're talking about the applicant. When it gets into the agent, no longer fees, it's revenue. So if you want the revenue to be paid account of the commercial bank or agents, then we use revenue. But if it is the fees, then it is the applicant who must pay the fees. And therefore, we have to be clear who we're about here. Do we want the applicant to pay the fees to a bank account, or do we want the revenue generated to be paid into a bank account? Yeah.
Mr. Speaker, it is the applicant that will pay the fee. But as the applicant is paying the fee, the registration officer or the third officer will receive that fee. And we are saying that whatever is received should be paid into the bank account open for that particular purpose. That's why I'm proposing that, saying fee payable. We say the fees collected. The fees that has been collected under section 1 shall be paid into a bank account open for that purpose. So we are placing the burden directly on the officer who is receiving the money, who is collecting the money.
I think this one is a policy matter. In this bill, who are you directing this one to? Who is the one asking to pay this? Or who is the one to pay to the bank account?
We can't pay the fees. But as you said, the moment it's collected, it becomes revenue. So we may be using the two words so that we are very clear.
But in this particular clause, we are talking about the applicant.
The applicant.
The fees payable.
Yes.
In that case, I don't think the bank is the appropriate place to ask. The fee payable shall be paid to other agents. After that, it's administrative. How the agency opening the account and things is administrative. Yes.
I think that the amendment he is proposing, if we say that the fees paid in subsection 1 shall be deposited in a bank account for that purpose, which means somebody else is going to do the depositing and not the fees paid shall be deposited in a bank account open for that purpose. I think that will take account of what is going on. It will be obvious and eliminated altogether.
All right. So you propose the appropriate amendment then, Honorable Leader.
Mr. Speaker, the fees paid under subsection 1 shall be lodged by the registrar into a bank account opened for that purpose. The registrar, as in 10-1.
Yes,
so the fees
for the
paid
consideration of the House. All in favor of the proposed amendment say aye. All against say no. The ayes amendment is carried. Now, clause 10, as amended, shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 10 as amended is added to stand part of the bill. Item XI.
Mr. Speaker, new clause. Amendment proposed. Add the following new clause. Retention of a percentage of internally generated funds. Despite a contrary provision in any enactment, the rest are retained not less than 50% of the monies realized in the performance of the functions of the registry. I so move.
What's the meaning of that? Not less than. Yes, Honorable Leader.
Mr. Speaker, really, I don't understand what the chair is trying to do. You say that despite a contrary provision in any enactment, the registry shall retain not less than 50% of the monies. And you are suggesting to them that every year they should take 100%. Is that the intent? Perhaps you meant not more than 50%. I'm not sure that you mean not less than 50%. But not less than 50% means from 51 up to 100%.
But not only that, if you're going to give them, for purposes of budgeting, it shouldn't fluctuate. So 50%, that's all, or 20%, but not less and not more, leaves room for fluctuation. Yes, Honorable Deputy Minister.
Mr. Speaker, I believe that this new clause more or less is introducing, let's say, funds of the registry. So the funds of the registry should then specify. For instance, if you look at the Narcotics Control Commission Act, when it comes to funds of commission, it says the funds of the commission include monies approved by Parliament, internally generated funds, grants and donations, and 50% of the proceeds realized from the sale of conscripted. So we may fashion that along this line, and that will be more specific. Yeah, it doesn't talk about not less than anything. If it's 50%, it's 50% of the fees that will be collected by the registry.
Okay, I don't see funds established anywhere. Yes, Honorable Member.
Well, it's a new clause that the chairman has introduced.
Mr. Speaker, looking at the new clause, I believe strongly they are talking about internally generated fund. We have stopped using the language monies realized in the performance of the functions of the registry. That is internally generated fund. So to propose a further amendment, despite a contrary provision in any other enactment, the registry shall retain 50% of the internally generated fund.
Yes, Honorable Members, the proposed amendment is for the consideration of the House. All in favor of the proposed amendment say aye. All against say no. Have it, the amendment is carried. Now, I think the heading should also change. It should be either comes under funds of the authority or sources of funds or something. So I direct the draft persons this proposed new clause under the appropriate heading. Clause 11.
Disclosure of information.
Amendment proposed. Chairman.
Mr. Speaker, clause 11, amendment proposed. Delete and insert as advertised. I so move.
All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 11 as amended shall stand part of the bill. All in favor say aye. All against say no. The ayes have 11 as amended is ordered to stand part of the bill. Clause 12.
Notification of birth.
Amendment proposed. Chairman.
Mr. Speaker, clause 12. Amendment proposed. Subclause 1. Delete and insert the following as advertised. I so move.
Yes, Honorable Member 4.
Mr. Speaker, my difficulty with this proposed amendment is the number of days that the person in charge of a health facility is to inform the district registrar or his or her representative. The 7 days, Mr. Speaker, I think is too long. It's too long, Mr. Speaker. Too long.
So how many days proposed?
Mr. Speaker, I propose that within 24 hours, it should be done at the close of every day. Because by the sheer arrangement of how the health facilities operate in the district, they communicate with the district health directorate by close of every day. So it shouldn't be difficult for heads of these health facilities to communicate the number of births at the end of every working day to the head at the district. It should be easy. It's a problem we are seeking to solve with this new enactment. So if we allow them as much as 7 days to be able to do that, Mr. Speaker, for me it's a problem for me.
Yes, Honorable Deputy Minister.
Mr. Speaker, that should be the ideal situation. But even we are saved by the fact that it says within. So if it can be done in a day, ideally, if everything had been computerized, this is very simple. You forward it, and the health director will also forward it to the registrar. But that's normally is not the situation, given our circumstances. But we are being given the way that maximum 7 days, this information should have been transmitted to the relevant authorities. I think under the circumstances, we should take it that way. If it's less than 7 days, it's good for all of us. But if you say in a day, you make the law, but you may not comply with the law, because the birth takes place somewhere in the municipality or district, as generic term, somewhere in the district, and then you're saying, let's say by close of day, if even it's by close of day, you are shifting to 3 days.
Yes.
Right, Honorable Speaker, thanks for the opportunity. I think within 7 days is fine, because when you look at the terrain in our various constituencies, some of the areas are kind of far, some are on the, and so some of them don't even have network. So if you say communicate within that time, and it's within 7 days is fine. But anything less or more, for me, I think it's not too good. It should be within 7 days.
Yes,
Mr. Speaker, even best practice, even in advanced countries, when you deliver at a hospital, you are not compelled to give that information to the registry, the birth registry in 3 days. Why? Because the hospital where the birth takes place creates the record. It takes some time for them to transfer that. So they will tell you, don't go there trying to name or create the name, because you need to get there and look at the record. So maybe when you give birth, they will say baby X, but the real name will come when you do the registry. It takes more than 3 days. I wonder why in this country we think that we can do it faster than even advanced countries. I think 3 days, a week is a start. We might even end up extending it if it doesn't work, but a week is reasonable in this case for now. So I humbly disagree with my neighbor.
The issue is the number of days. Is somebody's mic on elsewhere? Very well. Your mic is still on.
Oh, sorry.
Yes, Honorable Member for Kachisa.
Mr. Speaker, the provision is within 7 days. It's even an offense to go beyond that 7 days. So in making law, there should be some flexibility, so that within 7 days, if you can do it within 30 minutes, it's also within 7 days. Because the law is within 7 days. Within 7 days, from to the 7th day, you are operating within the 7 days. If you give a very late period, we may end up making the law. But when it comes to the enforcement of the law, that will be a challenge. Because we are creating an offense that when you are supposed to do an act in a stated period and you fail to do it, that is a sanction. So I believe the 7 days is proper, so that will give a bit of flexibility for compliance to avoid people being unnecessarily punished. So within 7 days, if it can be done within an hour, hour. You can still go ahead and do it within an hour. It's still.
As many as are in favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Item XIV.
Speaker, amendment, clause 12, amendment proposed. Subclause. Delete and insert the following as advertised. I so move.
Yes, honourable members, now we are on a bed attendant and we're given the same 7 days. So, yes, leader.
Mr. Speaker, we should be consistent. We are not there yet. But when you get to 90, usually we want to shroud deaths in some secrecy, not deaths. We announce deaths with some degree of excitement. But deaths, we want to hide deaths away from people in order for sometimes rituals to be performed before deaths are not. But when you come to deaths in 19, you are saying that it should be done within 72 hours or 3 days. I'm just telling you what you have done there. So if death, you want to have it done in 3 days, why are you saying that for death, it should be 1 week? It should be consistent. When for death, it should be 1 week as well. But for death, really is held in abeyance for some time. You are saying that that should be done in 72 hours. So if it is 1 week, commensurately, it should affect death as well. Otherwise, if you are indicating that should be done in 3 days or 72 hours.
So are you proposing that the 7 days be changed to 3 days? Is that what this is about?
Mr. Speaker, I agreed with the Honorable Dafiamepo, but the other members are saying that let's give ourselves 7 days. If that is the case, then when you go to death, you shouldn't say that it should be 72 hours.
Well, you're picking too soon to that. Very well. So the question is, all in favor of the proposed new clause in XIV, or amendment to clause in XIV, say aye. All against, yes, Honorable Mankango or...
Yes, the boy Mankango. Mr. Speaker, this is what the fact of that birth. The last but one, couldn't we simply just say which the birth occurs? It says the traditional birth attendant shall notify the district registrar or representative of the district registrar in the district assembly which the birth occurs of the fact of that birth.
I think so. For drafting purpose, the fact of the birth is not. It's not that what is. It's actually not what is being registered. The birth that is being registered. Within which the birth occurs. Of that birth, yes. So you are proposing deletion of the fact. Of the fact. All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item XV. Yes.
A deletion in IV should be of the fact of that birth. If you delete only of the fact, you leave of that birth, it will not well. So it should be a traditional birth attendant shall notify the district registrar or representative of the district registrar in the district assembly within which the birth occur within 7 days of the occurrence of the birth. So we delete of the fact of that birth.
Yes. Honorable Member for Adaglu.
Mr. Speaker, just to find out from the chairman, yes, people give birth at the hospital. Traditional birth attendants exist. Is it to be understood that in reality, some people do give birth on a farm? Or where...
This one. We come to situations other than
all
this
right,
one.
okay.
Right.
Okay, when we
So
get
all in favor of the amendment? Yes, leader.
Mr. Speaker, I agree with the deletion of the facts of that birth. But we should also delete in line 3, assembly. Because it will read a traditional birth attendant shall notify the district registrar or representative of the district registrar in the district, not district assembly.
Very well. Yes, so the final rendition will read, a traditional birth attendant shall notify the district registrar or a representative of the district registrar in the district within which the birth occurs within 7 days of the occurrence of the birth. All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, the clause 12, item XV.
Mr. Speaker, clause 12, amendment proposed. Subclause 3, delete and insert the following as advertised. I so move.
Other members for the consideration of the House. Yes, but Chairman, before we go there, I think the issue raised by the Honorable Member for Adaklu is a real situation, and indeed, I have a practical example. My mother's last child was born at a convention, a church convention. She went to the convention pregnant. She came back with a baby. Who is to report that? To provide for situations like somebody goes to farm, he comes back with a baby. Who is to report that?
Mr. Speaker, the community registrars will do that. The community registration officers will do that. They will report it and then record it.
Mr. Speaker, if that child was born in my village,
on Good Friday, call him Kofi Yesu, but his real name is Boapim.
If that child was born in my village, the name would have been convention.
Mr. Speaker, that is not correct.
No, Mr. Speaker.
Or blessing.
Are we going to give responsibility to the mother to report that? Are we going to put that in a law?
We have provided for community registration.
Yeah, but the community people must be aware of this before they can.
They tell that it's a communal thing.
When it comes home, he goes to report. He has a member for Huawei.
It's not that I can't immediately locate it, but they have put the responsibility on somebody who has knowledge of what has occurred to be able to make that report. I mean, if wherever you deliver, I mean, the person who has knowledge of it or who was there should be the one. But in the case of the convention, there will always be a health personnel, a nurse or somebody else who will assist in the delivery. And so the reporting should be on that person who has actual knowledge of it or knows the facts of it. I'm still looking
why
for
not the parent?
provision.
Why not the parent? He has another member for Achimda.
Mr. Speaker, clause 12 is notification. You are notifying the proposed register. Clause 13 is about someone doing the registration itself. So in this case, at the convention, is the mother. When she gets back, the mother under clause 13 goes to register the child. So it's all catered for.
Very well. Yes.
Mr. Speaker, the the provision that is presently before us is not curing the problem we have. And this is why. We are saying that where a child is admitted to a school, a preschool, in the registration district, and that is done without a birth certificate, notice should be given to the district registrar or his or her representative. I think he would rather say that where a child is to be admitted to a preschool, as part of the admittance, you should have a birth certificate. This one,
They say we haven't gotten there.
no, hold on. This one, we are saying that you should give notice. We are there.
Well, we are there now.
We are there now. That's where we are.
He has moved it, but
He has
I said
moved
it should
amendment.
wait
He has
while
moved
I
amendment.
raise the other question.
Yes.
So we're actually on XV now.
Yes. So that is my difficulty, Mr. Speaker. That we are still allowing a situation where people wouldn't have a birth certificate, even when the child attains 6 and is about to enter preschool. So I am saying the provision should be couched in such a way that, as part of the admission, the parent should be obligated on the parent to procure the birth certificate. Now the situation is that there's no birth certificate. The child has been admitted, but the school is now obligated to give that notice.
Yes, it is possible.
Yes, I agree that it is possible. But I am saying, instead of crafting the law this way, why don't we shift the burden rather onto the parent? That once you are ready to send the child to school, and the child has no birth certificate at the time you want to send the child to school, you take steps and procure it. Because by this law, we are making arrangements at the local levels for registration to even be done on rolling basis. On rolling basis.
Yes,
Because we are trying to avoid a situation where you deny somebody of a preschool just because the person doesn't have birth certificate. That is why we are saying that it should not even be a hindrance to you admitting the person. Admit the person, but within 7 days, notify that this child has been admitted without birth certificate. The Speaker, at the end of the day, the law will be passed and it will take effect from tomorrow. Already, people are born without birth certificates, and the law cannot go and take retrospective effect. And once you don't want the birth certificate to be a condition for admitting the student to school, there should be an allowance to allow such situations to be taken care of. So, imposing the burden on the school to inform so that they can do the birth for the child is in order.
Marco. Speaker, thanks so much. Speaker, I see a little problem. I want an explanation. We'll start from basic school or preschool. Is that the only point that people will appear without a certificate?
Where? What point? Is a manager of a basic school or preschool?
Pre and basic, Mr. Speaker. Preschool and then basic school. Why do we limit it to only preschool and basic school?
That is the entry point.
Oh, Mr. Speaker, we just dealt with non-formal education bill not quite long ago.
That is for adults. It's not for fresh, those born. Other members have put the question. All in favor of the proposed amendment say aye. All I know. The ayes have it. The amendment is carried. Item XVI. Chairman.
Mr. Speaker, clause 12, amendment proposed, subclause 4, line 1, delete not and insert 5 years of
upon the coming into force of this act. I so move.
The obligation under subsection 3 shall not be a precondition for enrollment. So you say you should delete the not so that it becomes shall be a precondition for the enrollment of a child at a basic school or preschool. Yes, I know. After 5 years of the operation of the law, you must present certificate before you are admitted. Yes, Honorable your issue has been brought back alive. The amendment is to say after 5 years, without a birth certificate, you can't enter school. Yes. That's, Honorable Members, the proposed amendment for the consideration of the House. Yes.
Mr. Speaker, unless the state will take the necessary steps to make this easier for everybody. Mr. Speaker, there are colleagues, including myself, who knows that within 5 years, certain constituencies may not have all that it takes to be able to do this effectively. So what happens if after 5 years, the state itself fails to put in the necessary measures to reach out to everybody?
What is missing today? Today, we speak. What is missing? If you give birth to a child today and you applied for a birth certificate, what are the challenges you will face?
There's none.
Mr. Speaker, there are places in my community that I am sure people living there have no business or they don't have any reason to come to a central point for a very long time. And unless you are saying that the traditional birth attendants would be everywhere, that people settle, that the records...
There are some people which you place the school under their next door, they don't go. The reason you're placing some restrictions here, that this time, if you don't obtain a birth certificate, you cannot access B, C, D, E. You know, but I thought you were going to say you have no district registration officer, and within the in the district, in the Adaklu district.
No, Mr. Speaker, the district will surely have, but maybe unless the state will say that the district birth attendant would reach out to every settlement, then it's not a problem. That is what I'm saying, that unless the state takes the necessary steps to ensure that, then the law itself would not be...
All right, and I don't have any such problem, so, yes, Leader.
Mr. Speaker, the problem that is alluding to is cured by the bill. When you have community, when you have zonal registrars, when you have community settlement as each town. And even the towns, if the towns are big towns, you can't have one. You may have, the town itself may be zoned into various communities. They themselves will have the registrars. So they'll be visiting homes regularly. Who is dead and who has given birth to a child, a son, daughter, and so on and so the many faults, and record these things. So we don't have any excuse. We don't have any excuse not having a birth certificate or not being registered. That's the purpose of the bill.
All in favor of the proposed amendment, say aye. Against, say no. The ayes have it. The amendment is carried. Now, clause 12 as variously amended shall stand part of the bill. All in favor, say aye. All against, say no. The ayes have it. Clause 12 as variously amended is ordered to stand part of the bill. Clause 13.
Registration.
Amendment proposed. Chairman.
Clause 13, amendment proposed, subclause 5, paragraph A. Delete and insert the following. By the father or the mother or both parents of the child, or I so move.
Yes, Leader.
Speaker, unfortunately, I couldn't continue with them. But in 4, 13.4, I think there was an issue about the word deserted, where a newborn child is found deserted. And there was the issue about
We
whether
can
to
probably
substitute.
change to abandoned. Instead of deserted, abandoned.
Yes. I wanted to know if they eventually settled on, because it's not advertised.
Yes, Deputy Minister, Honorable Deputy Minister.
Mr. Speaker, if I heard leader very well, it was about desert and abandon. In fact, if you look at the technical meaning of desert, that should be to be used. If you Google the meaning of desert, it involves leaving the child as the normal word would have been abandoned at desert, to desert the child. I don't know whether that's what you want.
Which one would resonate more with Ghanaians? If you say abandoned,
Desert. Desert
deserted
has a broader meaning than abandoned. If the Speaker may refer you. The old law has desert.
Who has desert?
I said the old law has the word desert. Mr. Speaker, leader put up this argument at the winnowing committee. I think he was defeated, but he said he was going to bring it here. So I'm running of it. And he has brought it here. I said you brought up this argument when we were doing the winnowing. And he said we were going to go for abandonment. Huh?
Honorable member.
I wasn't there.
No,
Okay.
Mr. Speaker, I would want us to go with abandonment. Because though desertion will amount to abandoning a child, we can have a physical abandonment of the child, an emotional abandonment of the child. And it will all come together to mean abandonment, desertion of that particular act. But if you use abandonment, then you are talking about the physical act of the child being abandoned, not the emotional element of it. But in this particular sense, we want the physical abandonment of the child. So we should use the word being abandoned.
Yes, honorable members, I want to hear more views on deserted and abandoned child. Which one?
It doesn't, Mr. Speaker, it doesn't connote any emotional situation. It's where the child has been found and appears not to be any responsible for the child. And then that situation comes in. It's not about living with parents, but emotionally having been abandoned. So you use the word desert. So with all due respect, Mr. Speaker, let's stick to the physical situation, not the
Very well.
emotional.
It's the same, so. But the proposed amendment, you're saying that we should delete and insert the following: by the father or the mother or both. Shouldn't it be by the father, comma, the mother or both? Yes, Chairman.
Yeah, Mr. Speaker, we'll go with that. We'll go with that. The
Very well. So the nation will be by the father, comma, the mother or both of both parents of the child. All in favor of the proposed amendment, say aye. All against, say no. The ayes have it. The amendment is carried. Item XVIII. Yes.
Speaker, I just want to get this. If the mother or either one of the parents abandon them, would that necessarily amount to abandonment? Because if your father is not your mother,
we have moved to a new subclause. Now we are dealing with subclause 5.
Yes.
We have
5A.
have to register. Yes. Except an abandoned child, the father, mother, child may register in B.
Yes.
In the case of death or incapacity, the father of the father also. So the abandonment is the other side.
yes, that's what we just did. Yes, so my question is because the new rendition says by the father or mother or both, and I'm saying that you couldn't say somebody is abandoned if only the father or the mother is not there.
There are two different subclauses. We are not dealing with abandonment, we are dealing with registration. So,
Okay.
4 deals with when a baby has been deserted, who can register a baby, and 5 is saying, with the exception of a baby who has been deserted, it is the parents, mother and father, or both, who can register. And if either of them is there, that is B. Right. So, XVIII. Chairman, yes, Honorable Member for Makambo.
Mr. Speaker, XVII, we can delete the second day. So by the father
We are dealing with XVII, or you want to go back to what we...
Yes, Mr. Speaker. I mean,
very well.
There's a second day that we can take away. So by the father or mother of both parents of the child.
What we did was to say by the father, comma, the mother, comma, or both parents, or both parents of the child. So that's the new rendition. Yes. We'll continue at XVIII.
Mr. Speaker, clause 13, amendment proposed, clause 5. Paragraph B, subparagraph II, delete a person and insert an adult.
Honourable members, the report is for the consideration of the House. All in favor of the proposal, say aye.
Helpful if the chairman will give us,
justify.
because if you remove a person and an adult, and just we should vote on it. At least tell us why. Well, yes, then say that is the meaning of interpretation. But everybody in this house is not a lawyer. So if you throw your hands and say interpretation, everybody is not a lawyer.
Well, if the law said a person, it includes minors, includes inanimate persons, yes, companies. But if you use person, then the responsibility is a human being who is capable of, if you use adult, a human being who is capable of reporting. Honourable Member for Danzaspa, you've been on your feet.
Thank you very much, Mr. Speaker. Well, I hear my colleagues saying, hey, I'm around. I'm trying to, but the COVID, I mean, I see your face at the COVID. So, Mr. Speaker, unfortunately, I wasn't here when this matter actually first came to the floor. But I have a fundamental issue which I intend to raise. I'm wondering if there will be the need for what we are doing. You see that I was flipping through a document. It's a solution. Desperately looking for the appropriate provision, which I can't now find. Mr. Speaker, it is a part of this constitution that I think nobody, executive, I suspect, including the legislature too, should attempt to circumvent a judgment of the Supreme Court. If you did that, I think you are the president. It's a high treason. It leads to your impeachment and all that. Speaker, we dealing with this document that deals with the registration of birth and deaths. The purpose, I suspect, of this registration and all that is to serve as some sort of identification that we were born in Ghana and we're Ghanaian. Well, it's a record. My colleague says it's a record. What kind of record? It shows that you were born, you are recorded as having been born, and that certificate that will be given to you. I'm sure I haven't read, but I know upon registration, some sort of document will be given you so that you have been born in this country and registered as such. The Supreme Court seems to be saying that it's not the law. Certificate. Is that, I haven't finished. Why are you saying no? I'm
listening to you, Honourable.
Thank you very much, my everything. they waste our time, so let's talk proper stuff. They are saying that, if I understand properly what is going on, that the birth certificate itself is not a means of identification of anything. It doesn't mean that you were born in Ghana, anything. And really, the value of it really seems to be basically zilch, Ms. Speaker. I'm wondering if by what we are doing, we are not undermining the Constitution. You keep saying, no. Let me listen to the speaker, not you. You are going to teach me anything. He will teach me what I want to learn. Well, that section, and then, of course,
Honourable members,
Mr. Speaker.
I don't want us to go near the Constitution. There's an existing law on a registration of and death. We are reviewing that law, and the purpose is contained in the memorandum. This review is intended to assign responsibility for the registration of births and deaths to district assemblies, who, in consultation with the registrar, are required to appoint a district registrar of births and deaths, registration officers for the district of the registry. Members of the unit committee in each district are to constitute registration assistants in each district. The purpose of the review, therefore, is to allow for registration of births and deaths in the whole country. To allow for the, yes, it is to make the district registrar responsible for district assemblies, to ensure that all registration officers at post continue in employment, and to deploy staff of the headquarters to the districts and sub-district structures, period. That is what this law is about.
Yeah, thank you. But really, it reinforces the point we are making. I think what just slipped out of your lips really is that we are enacting this to assign responsibility for registration of birth and death. Is where the issue is the registration itself. We're not dealing with that for the time being. We're talking about because you register the person and then give the person a certificate. The certificate is the service. If it is not to identify you,
the certificate will register the fact of your birth. That's all.
The fact of your birth.
Of your birth.
And then what do I need that for?
I don't know what you need that for. But whatever you use it for.
I defer to you, Mr. Speaker.
Please, let's
My
proceed.
fear is that we are breaching the Constitution.
No, we are not dealing with citizenship. We are not. Please, let's proceed. Let's proceed. Yes. We are on, we're going to put a question on deleting a person and is substituting with adult. All in favor of the yes, leader.
Mr. Speaker, I just want to inquire from the chairman whether we settled on an adult person.
Order.
An adult person or just an adult. I think we said an adult person present at the death. It shouldn't just be any person. We said an adult person. Because in many places we have used adult person. Does he want to make it simpliciter adult? If it's adult here, the word adult person appears, you should delete person. We don't have adults. But there are many places where we have adult person. There's a reason why I reminded them of that and they brought it to qualify the person. So that was what was done. If non-adults, simpliciter, then it means that wherever adult person appears, they should delete person and have adults.
But that will not be appropriate because we actually also have minors having delivering. And so in that case, for example, I will not be, you cannot apply I to them because the person who is in charge of the child at the time herself is a child. At 14, she has delivered. But she also is responsible to report. Yes, Honorable Fellow.
Mr. Speaker, my difficulty with an adult simpliciter is that it is not every adult who may be seized with the fact of the birth of the child. So if we are deleting a person and substitute with an adult, we may run into some difficulties. So we need to qualify.
Is there an adult, if you are to become an adult present at the birth?
Very well. Very well.
But the issue really is about whether you're substituting every person here with adult, which leader has.
That's not what I said. I said that in other areas we have used adult person present. So I just drew attention to that, and then they brought this qualification to qualify this particular provision, to have it read as an adult person. Here now is just simplicity, an adult. I'm just telling them that in that case, those other circumstances where we have adult person, when we get to delete the person. That's all that I'm saying. Because in those other areas, it's adult person, adult person.
Yes, Honorable Akachisa.
Mr. Speaker, I suggest we deal with the II. Then when we get to the III, then we deal with that one. And not support using the word an adult person, because an adult is a person who has attained the age of a majority. So the use of adult suffices.
Very well. So as many as are in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item XIX.
Clause 13, amendment proposed. Subclause 5, paragraph B. Add the following new subparagraph. The next of kin, if the next of has knowledge of the birth. I so move.
The next of kin of who? Of the child or the parent?
You're talking of the parent here, Mr. Speaker.
I think it's not necessary. I don't know. Yes, you are the draft person, the draft member for Wild West. What is the purpose of inserting the next of kin as a person to report the birth?
Mr. Speaker, I wasn't quite following, so I'm lost.
Very well. 13 subclause 5B. 5B has, in case of the death or incapacity of the father and mother, 1, by an occupier of the premises in which the child is born, if the occupier has knowledge of the birth. 2, a person present at the birth. Or 3, a person who has of the child. And you're saying that you're adding the next of kin if the next of kin has knowledge of the birth. The next of kin here, we have the mother, the father, or the parents. No, who's next of kin? Is it the next of kin of the mother or the... If you are giving responsibility, it should be specific.
Mr. Speaker, you are talking, it refers to the father or the mother. That's of kin of. Okay. That's of kin of any of the parents who has knowledge of birth.
Yes, honorable members, for the consideration of the House. Yes.
Mr. Speaker, I thought the adult covers the next of kin. An adult, it can be next of kin and any other.
Maybe you want to give priority, but in that case, then the next of kin should precede the adult. Yes, leader.
Mr. Speaker, 5 provides that except in the case, especially in subsection 4 or subsection 5 or section 18, prescribed particulars of registration shall be provided to the district registrar by the father or, as you directed, the father, the mother, or both parents of the child. Or, in the case of the death or incapacity of the father and mother, by and in terms of progression, the next of kin should be first. The next of kin of either parents, that is mother or father, who has knowledge of the birth. That should be the first port of call. And then you come to 2. The original one, which is Roman number 1, will be an occupier of the premises in which a child is born. That is, if the occupier has knowledge of the birth. So that's
very well. So I'll put a question on this one and direct the draft persons to place the new clause appropriately. All in favor of the proposed new clause say aye. All against say no. The ayes have it. The amendment is carried. Now the draft persons are directed to place the proposed new clause at the appropriate place in the sub-clause. Item X.
Mr. Speaker, clause 13.
Yes, Honorable Leader.
Mr. Speaker, when I went back to the Winnowing session, I raised an issue with respect to 5B. You're talking about, in the case of death, the father and mother, or maybe the incapacity of the father or mother. In the bill, it has incapacity. The Speaker, they will lack capacity if you say they suffer incapacity. But is it incapacity or incapacitation that we want? I thought we should be very clear in our minds that in the context it should read incapacitation. That is,
are the lawyers familiar with any law in which we have used incapacitation?
Mr. Speaker, here in this country is the death of the parents, or they are so incapacitated that they are not able to go physically to do the registration. But here it is incapacity in the bill. I'm asking whether we are sure it is incapacity or incapacitation in the context that we want. My own thinking is that it should be incapacitation, but if others have superior arguments, they could bring it.
Yes.
Mr. Speaker, in the legal sense, incapacity means physical or mental inability to do something. So if you use incapacity here, that's the essence of the word, meaning of it. It doesn't have to be incapacitation. Incapacitation is more or less injury, disability, but incapacity means physical or mental inability. It's not the where they say that you don't have them, so you lack the capacity. What is being used here is the physical or mental inability to perform. So he said emotional. So incapacity is okay.
Yes, Honorable Member for the
Mr. Speaker, we've got to be careful about this dichotomy. Incapacity would not necessarily be, not necessarily. I mean, being not physically able to do one or two things in the context of what we are talking about is not incapacity, particularly because of what my colleague talks about, what he's talking about. Incapacity, Mr. Speaker, would almost always, in the legal context, would have something to do with the mental. So when the person is not mentally incapable of doing something, I'm not sure this rendition it's the appropriate way of going about what he means by both the physical and then the mental. So if he wants to deal with both, I think it has to be stressed properly. We're talking about physical inability or mental inability. Incapacity would take us to court and we'll be arguing about incapacity, but which one we're talking about.
Yes. Wow. I think that the issue of incapacity is sometimes related to the mental situation or age, where you don't have the rich majority, you are not capable of making decisions. So, but the incapacitation, disability of occurring as an injury, that is not what we will be talking about here. We are talking about incapacity in terms of decision making, that the person is of not sound mind, of no age, legal age to take a decision. That is the kind of incapacity we are referring to here.
So, we have taken a decision on that issue already. Yes.
Mr. Speaker, with respect, the explanation being proffered by my colleagues clearly off track. Here we are talking about the parents. We are saying that the parent doesn't have the capacity in terms of age. It's not so. We are talking about the fact that the person is not able. That's why I'm saying that what he's saying is inaccurate. The person.
I think you should get that right. What we're trying to.
Well, I have not given you the floor. The leader was. Yes, Honorable Leader, please come.
Mr. Speaker, I am saying that here we are referring to the death of the father and mother. So physically, they are not present. Now, they may be present, but they may be incapacitated to the extent that they are not able to physically go and do the registration. It's not incapacity. But, Mr. Speaker, of course, this is the last time I'll talk about that. It's not incapacity in this context. It should be incapacitation.
Members, why are we introducing controversy to some things which are known and legal? These are terms that are used regularly, so please let's proceed. Item XX. Honorable Member, are you going back to capacity and so on? But, yeah.
But while dodging incapacity, I will still be under BIII. So below incapacity, you have II, where we did an amendment to an adult in place of a person. I presume that we will same to III. But in reading III, a person or an adult has charge of the child. It doesn't make sense to me.
We didn't do that. I as a person who has charge of a child.
But not an adult.
We didn't amend that to adult.
But
no, we shouldn't. Because you may have a minor who has charge of a child, as a parent, the mother in particular. You have 4 to 15-year-olds who are giving birth. Right. Yes, Honorable
some discord and cacophony somewhere, and that we should move
forward. Honorable, please, I want to move on from there. I'm on item XX.
That's right. So I'm asking, what have we accepted? What have
we had already taken a decision on that, and the leader thought we should reconsider capacity or incapacity.
So rule him out. Now you should take his capacity away. Okay, that's fine. Thank you.
Item XX, please. Yes, Chairman, did you move your motion?
Mr.
Mr. Speaker, I did that for clause 13, subclause 5.
We are now XX, subclause 6.
No, I've not done that. Mr. Speaker, clause 13, amendment proposed, subclause 6, delete and insert the following as advertised. I so move. Okay. Where a BEV is not registered within the... Yeah, but maybe he wants it for... Where a BEV is not registered within the 12 months period, the district registrar shall, by notice in writing, summon any of the persons referred to in section 5 to attend personally at the BEVs and DEVs registry to provide the prescribed particulars for the registration of the BEV within the dates and times specified in the notice, and the person summoned shall pay the prescribed fee. I so move.
All in favor of the proposed amendment say aye. All I know. The ayes have it. The amendment is carried. Item XXI.
Mr. Speaker, clause 13, amendment proposed. Subclause 7, line 2. After months, insert but not more than 5 years. And before registrar, insert districts. I so move.
As many as are in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Item XXII.
Mr. Speaker, clause 13, amendment proposed, subclause 9, opening phrase, line 2, delete the person responsible for the child. I so move.
Subclause 9. Where does the person responsible for an opening phrase? Subclause 9, unless the district registrar is satisfied that an earlier registration of the bed has not been made in the district. So the amendment does not sit with the subclause. Please flag it and let's proceed. 13.9. You have even deleted it here. 13.9. Paragraph B, delete and insert the following. Subclause 9, paragraph B, but there's no paragraph B to subclause 9. No, Chairman, rather, I'm the one confusing you. I was reading a 9 which is a part of 11. Okay, so best shall not be. Delete provides, and which one was the sub 9? The person responsible for the child. Yes,
Mr. If I may take the rendition so that you'll be clear. 13 subclause 9. A BEV shall not be registered after the expiration of 12 months from the date of birth unless A, district registrar.
That is why we are deleting,
yes,
so it becomes all right.
District registrar receives a written authority of the registrar directed at.
So you delete the provides.
Yes, you put the provides and then bring in district registrar receives.
That combines two amendments. That's why we are confused. Okay, so we'll delete unless the person is responsible for it. And then when it comes to A, we'll delete subclause 9, paragraph A, line 1, provides, and insert a district registrar receives. That makes it clear. All in favor of the proposed amendment say yes, Honorable.
The district registrar receives is under SXIII.
So I'm saying, unless we combine the two amendments, it doesn't make sense.
Yes.
So I've combined the two amendments, and I'm proposing all in favor of the proposed amendments in XXII and XXII. Yes.
Mr. Speaker, I shouldn't be asking the chairman to do this, but on this occasion, I will want to ask the chairman to give us the new rendition. And in giving us the new rendition, it will be realized that the deletions that we are doing, it won't sync with the A and B.
It actually did, and that's why I saw that we need to combine it. Yes.
Mr. Speaker, and even that, if it ends at receives, then it doesn't flow with A and B.
Which one ends at receives?
If we combine the two
shall
amendments.
not be registered after the expiration of 12 months from the date of less a district registrar receive rating authority of the registrar directed at a particular district. So if you take the two together, then it makes sense. Delete provides, insert registrar receives, then it continues. Right. All in favor of the proposed amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, item XXIV.
Mr. Speaker, clause 13 amendment proposed. Subclause 9, paragraph B. Delete and insert the following. A person responsible has paid the specified fee for late registration. I so move.
All in favor of the proposed amendment say aye. All against say no.
Mr. Speaker, I think some words are missing in the proposal. He left out for the child. We deleted the person responsible for child in the preamble in it. He wants to bring it down to B. So you should insert those words. A person responsible for the child has paid the specified fee for the late registration. That is how it should read.
Very well, honourable members. The new rendition will be a person responsible for the child has paid the specified fee for the late registration. All in favor? All against say no. The ayes have it. The amendment is carried. Now, item XXV.
Mr. Speaker, clause 13 amendment proposed. Subclause 12 delete. I so move.
All in favor of the amendment say aye. All against say no. The ayes have it. The amendment is carried. Now, clause 13, as variously amended, shall stand part of the bill. All in favor say aye. All against say no. The ayes have it. Clause 13, as variously amended, is ordered to stand part of the bill. That brings us to the end of consideration of the registration of Birth and Death Bill 2024 today. Honorable Majority Leader, you have the order paper addendum 3. What do you propose to do with that?
Yes, Mr. Speaker. We'll do the presentation of the document on behalf of the Minister for Finance, and then the second one will be on behalf of the Minister for Roads and Highways.
Very well. A, by the Minister for Finance. Aye.
Covered Buyers Credits Facility Agreement between the Government of the Republic of Ghana, represented by the Ministry of Finance, and Belfast Bank NV and KBC Bank NV as arranger and Belfast Bank as agent for an amount of 72,150,000 to finance the construction of the Park Grant Interchange, roads in Sekondi and Takoradi Township, Phase 1.
Honourable members, the paper is duly presented. It's referred to Finance to consider and report. Item II.
Term loan facility agreement between the Government of the Republic of Ghana, represented by the Ministry of Finance, and BMCE Bank International PO as a arranger, and Global Loan Agency Services Limited as agent, for an amount of 65 million euros to finance the design and construction of 3 bridges over Sweet River in Ituri, Ankobra, at Ankobra and Black Volta River in Digbe.
The paper is duly presented. It is referred to the Committee on Finance to consider and report. Item III.
As far as loan agreement between the Government of the Republic of Ghana, represented by the Ministry of Finance, and Cooperative Robobank UA, for an amount of 27,651,152 euros and 61 cents, including insurance of 3,410,852,000 euros 61 cents by Atradius Dutch State Business NV to finance the construction of pedestrian bridge at hazardous locations in Ghana.
The paper is duly presented. It is referred to the Committee on Finance to consider and report. IV.
An agreement between the Government of the Republic of Ghana, represented by the Ministry of Finance, and Cooperative Rabobank UA, for an amount of 4,277,700 euros to finance the construction of the pedestrian bridges at hazardous locations in Ghana.
The paper is duly presented. It's referred to the Finance Committee to consider and report. Item E.
Request for waiver of import duties, import VAT, NHIL, Get Fund Levy, Exim Levy, Special Imports Levy, and Domestic VAT, amounting to the capacity equivalent of 7,072,326 euros and 38 cents on materials, equipment, work and services to be procured for the construction of pedestrian bridges at hazardous locations in Ghana.
The paper is duly presented. It's referred to the Committee on Finance to consider and report. Item B. I.
Design build contract agreements between the Government of the Republic of Ghana, represented by the Ministry of Roads and Highways, Department of Urban Roads, and VIA BUILD Africa, for an amount of 65 million euros for the design and construction of the Park Grant Interchange and Arts in Sekondi and Takoradi Township, Phase 1.
The paper is duly presented. It is referred to the Committee on Roads and Transport, consider and report. Item II.
Design build contract agreements between the Government of the Republic of Ghana, represented by the Ministry of Roads and Highways, Ghana Highway Authority, and Grinder Engineering Limited, for an amount of 58,138.80 cents for the design and construction of 3 bridges over Sweet River at Ituri, River Ankobra at Ankobra, and Black Volta River at Digbe.
The paper is duly presented. It's referred to the Committee on Roads and Transport to consider and report. Item III.
Contract agreements between the Government of the Republic of Ghana, represented by the Ministry of Roads and Highways, Department of Urban Roads, and Jason Bridgen International Weaving of Netherlands, for an amount of $28,518,000 for the construction of bridges at hazardous locations in Ghana.
The paper is duly presented to the Committee on Roads and Transport to consider and report. Honorable Leader, I think at this juncture I can bring this to a close.
So, Speaker, so we
Very well.
resume on Wednesday, tomorrow being a public holiday.
Yes, tomorrow is a public holiday. Forgotten about that. The House is adjourned to Wednesday, the 5th of August, 2020, at 10 o'clock in the forenoon.